se mi dà la parola poi.
Persone sono collegate. Sì. Ok, perfetto. Sì, tu hai quello che...
Good morning to everybody, and welcome in this raining day in Milan. I'm very happy to introduce the day, which is going to be a tight day because many people are going to speak. And because the main idea of pushing Anna Maria to make a proposal recover was originating when we at Transcrime were analyzing the confiscation and the seizure decree in Italy, and I went to the head of the agency dealing with this kind of matter in Italy, and I asked him, look, Prefect Frattasi, his name, we know the data you have in your hands, thousands of decrees every year of seizure confiscation of the proceeds from crime. Could you tell me how many are you doing abroad? He said, Ernesto, I don't know. I think, for what I know, in the fingers of one hand, with 2,000 seizure in 1 year in Italy, fingers in one hand. He said, let me understand more and look. And after he called me on my phone and said, well, I know one in France, one in Belgium, somewhere. I thought my answer was the following. If criminals know what is going on, this is really a very good incentives for investing abroad, for sure. Because what we are doing is calculating the risk of confiscation, not only of conviction, and the risk of confiscation in proportion to how many confiscation you do in a single country. So if people open pizzeria in Germany, as they do, the risk of confiscating the pizzeria in Germany is 100 times less than the risk of opening a pizzeria in Italy, for sure. This is the, well, after trying it was before the 2018, and I think in 2018, the regulation came out, implementing in 2020. And together with Anna Maria, we decided it was a valuable idea to propose to the European Commission to explain, to understand what was going on, because there is the political need, it's a political need, at least to fill the gap between confiscation in a single country and confiscation abroad, just to avoid the risk that people move abroad, and criminals we know are quite clever enough to go abroad. Well, today I think we can have in front of us the first raw output, that means knowledge. And collecting this knowledge, which means collecting the data about the flows, how many requests have been done by a single country to another country with flows. In a way or in the other, we have some data. In Catania, I remember I was really surprised in listening that Lithuania has much more requests than Italy. Lithuania has 5 million inhabitants and Italy has 60 million inhabitants. In proportion, we need to understand that Lithuania is full of criminals, much more than Italians, but I doubt. But it is quite clear that there is something that does not work in the mechanism. And the idea of recover is to produce knowledge for the European Commission, because what we discovered also, that the European Commission does not know And when Professor Maugeri asked to DG Justice to provide data, there was some problem in providing data. And after the data they sent were raw, not very well organized, absolutely difficult to be understood. Today, thanks to Mr. Insolera and Mr. Matteo Anastasio, we will have the first output of this project that give to you the idea is a matrix I have suggested to do to fill. At least looking into the data which are coming from your answer, your presentation, data from the DG Justice and other data coming from the Italian government. And I ask you to pay a lot of attention to this table and to go through and help us, because this is really a good output of the projects, to fill the gaps, because the end results of this matrix will be to have in front of us a rough idea of how the regulation is working. And this is really preliminary to modify and to suggest interventions at a low level, organizational level, and other level. Because if we don't know what is working, and if it's working, and if we don't know the data, we can't suggest anything. Yesterday, I was listening to the ad case. I was expecting a little more than a narrative about what happens, such as the symptoms. I was expecting the diagnosis. But yesterday they came out with the symptoms. I think we need to have a diagnosis. It's a completely different thing if I say to the physicians, I have a pain here, blah, blah. I want to know what he thinks about the diagnosis about my pain. And because the diagnosis will help us to put the fingers where the things don't work. And something came out yesterday about the hard cases when things don't work and how to modify these things. Because I want to translate what I'm saying today in a positive way. We have the duty to suggest what, where, how, and when modification should be taken by the European Union in terms of making the regulation not only more implemented, reduce the amount of difficulties that different countries are meeting. Yesterday, there was a discussion about legislation asymmetries. There are organizational problems. There are a lot of different problems which are making international cooperation on this field lower at the point that I hope we will fill this matrix with other data, comparing how many requests have been done by a single country to the other, how many confiscations and seizures have been done inside the country. And we will see the difference between what the countries do inside and what the countries do outside. And this will be extremely interesting as a product, because this is what I thought at the beginning of this project, asymmetries between the data, and which explains. Italians don't know how much do they request. The Minister of Justice have some data, but the Minister of Justice is not collecting all the data because prosecutors in Italy go directly to the others. So also the Minister of Justice in Italy does not know. And yesterday I was listening to Germany. We do have the data of Germany, but you Germans don't have the data. It's surprising me a lot, which means there is no country which knows how things are moving. And if I ask it to the Minister of Justice in Italy, they know what's happening there. When I ask it to you about, they know what happens for the Eurojust, but they don't have a vision, a general vision about how things are working. So none in Europe has a vision of how the regulation is working. Not a single country. The example of Germany, he was explaining what does not work in Germany, and we have the data about Germany. And some data about Germany, some data, better than nothing. In Italy, it's exactly the same thing. I have been speaking with the prosecutor in General Milan. Say, we don't go to the Minister of Justice, we just go and request directly. I said, what does it mean? Do you inform the Minister of Justice about? No, waste of time. So Eurojust, as you explained to me, has some cases which are, because this is the function of Eurojust, but Eurojust is not collecting all the data related to the implementation of the work. So no one has a vision about what's going on. Having said this, as introduction, I welcome today, because this international conference is really crucial for achieving these first good results of the project Recover, or one of the results, that will be producing knowledge, at least if the project will end with this systematic knowledge filling the gap. It will be extremely interesting for those people who are listening our report to say, hey, finally, somebody with the money of the European Commission has produced what we don't have. And I stop here, welcome you once again in order to fill the gap when Matteo Anastasio will show on the screen what is going on in Europe. Thank you.
Thank you. Welcome again to everybody, and just some very preliminary remarks. Just as yesterday, I invite you to, first of all, stick to times, because today we have a busy schedule, so we risk not to allow everybody, to fully express their view. So it is important to stick into 20 minutes we have, so maybe 15 minutes of presentation and 5 minutes of question, let's say, something like this. Then again, we are recording this event, and we are here with the consent of everybody for the recording and the publication of the recording on our website and on our database. Then I invite you to sign, as yesterday, the attendance list we are circulating now. As yesterday, we have the presenter, so who is speaking will have the presenter. And then please speak to the microphone. Today is more important than yesterday because we have a wide audience from remotely, so they won't hear us unless we speak to the microphone. And finally, you see projected the EU survey. The EU survey is a service by the European Commission to assess the quality of the dissemination events that are within European projects. We really invite you to compilate this. You can see it's a little bit complicated, I would say. You have to pay attention to the references that are there, because you have to insert them into the form you will find at the link. But this is really important, both for the physical attendees to this event, and to the ones that are following remotely. So please click on the link if you can, or we will send the link to all our partners, and these are the information you will have to insert within those categories. Additionally, you find the links of our social media pages to follow us. Thank you.
So we start now with the presentation. Thank you so much to everybody for being here in Milan in presence or online. The aim of this conference is starting to spread, to share the first outcomes of our research. And so we start with the presentation of Matteo and Pietro, even if Pietro Insolera is not here today for health issues. And it is a first important outcome. We try to prepare this framework of the models of confiscation which are covered by the regulation, and about the problems, the issue in the application of the regulation, and the best practice in the first praxis. Please, Matteo, I give you the floor.
Thank you very much. And again, welcome everybody. I'm Matteo Anastasio, I'm a PhD candidate here at Transcrime. And this presentation was done together with Pietro Insolera, who unfortunately can't be here. And he sends his greetings and apologies for this The presentation will illustrate a little bit also for the benefit of the audience what the structure of the project and what we have been doing during this month, and then we will delve into the output we are trying to build on this schema that is useful for many purposes. So, first of all, stick is not working. Okay, okay. Okay, so first of all, context and aims. As you know, probably transnational crimes, especially crimes in general, transnational crimes exploits legal barriers between member states. And so ensuring the harmonization between member state legal systems is, of course, crucial. The literature, let's say, distinguishes between positive and negative harmonization. And Recover deals with both these aspects of harmonization. Positive harmonization is about approximating the legislation of member states, while negative harmonization is, let's say, extending the territorial validity of acts, meaning ensuring mutual recognition, which is the center of the regulation and the center of our project. As I was saying, our project addresses both these aspects. So on the first phase, we deal with what is the state of approximation between member states legislation and what we can do to get it better. And in the second, let's say, phase, we try to analyze the principal instrument of mutual recognition we have in this domain and understand gaps and loopholes. So this is, of course, relevant for many, many reasons. And this is what recovery is about. It is about the efficiency of the judicial process, because we simplify the judicial process, we avoid duplications, and a fast and effective mutual recognition is crucial for this. Of course, prevention of capital flight, we know, follow the money, all this approach. And this is, trying to impede the capital to escape is crucial for an effective enforcement of the European law, the European criminal law. Of course, also central concern of our project and of the regulation is the protection of victims, and mutual recognition and confiscation is something about this, and strengthening mutual trust. And this is also why we are here all together at this table, for enforce and raise the awareness about this subject. So very briefly, the structure of the project, we have many, many packages that you can see here. We are ending the third package now. And as I was saying, the first and the last one are on project management and on dissemination. And this is an event that is within the framework, within the working package of dissemination. Then we have VP2 that we have concluded in June, related to establishing the subject matter of the regulation. And Professor Maugeri will give some hints about this, that fuels VP3, that is the one we are now, that is on identifying the practical obstacles and legal issues related to the implementation of the reg. And then we will assess the possibility to apply the reg to legal persons and enterprises. And then eventually we will conclude our project with an assessment of asset recovery offices, activities, and management of frozen assets. So this is really for the benefit of the audience. This is our consortium. It is very large. It is we have many, many law enforcement agencies, and these allow us to give a little bit of practical knowledge and practical material to our research. And these are all the logos and the contacts. You can find them on our website. So really briefly, what we have been doing during VP3 and VP2 and VP3 is, as the partners can testify, we have collected questionnaires mainly. We have done workshops, and we have collected all the materials we could in order to solve our first issues that are related to establishing the concept of proceeding criminal matters and identify the national form of freezing and confiscation. The outputs are wide, are reports, guidelines. You'll find everything on our website within the database. That is a useful tool to understand our research and a practical tool to understand the confiscation framework in Europe. The same we have for WP3, where the focus was on identifying the practical obstacles. We have used the same materials, meaning questionnaires, reports, desk research, workshops. Additionally, as I will discuss, we have asked the Commission to give us the data about the regulation, which was one of our main concerns. So, having said so, we go into the main output. For now, we are trying to, the instrument we are trying to use in order to concentrate all this knowledge and to make it useful for practitioner and for research. So I will show you the schema, which is based on Excel and is divided mainly in two parts. First of all, national models of confiscations and issuing and executing authorities among member states. And second part is statistical data on the use of the regulation and the issues, meaning normative, practical, and best practices. The sources, as I was saying, were national reports, results of the workshop, external sources, desk research, everything we could collect about the implementation. The utility is, as I said, for law enforcement agencies. It is a useful instrument, a useful tool for for officers to have a quick overview of, the state of harmonization between member states. And for example, if a law enforcement agent has to send an order, it could have an overview of issuing, executing authorities, forms of confiscation, legal basis of them. We will see everything. It is also useful for research purposes because it gives a comparative overview of data and knowledge we have about, and also, of course, for policy issues because it helps policymakers visualize and then take decisions about this matter. Issues I wanted to underline very clearly that we had a huge problem of data. We have tried with everybody and we have tried with many sources, questionnaires and everything. Eventually we have asked also the Commission, the statistical service of the Commission that provided us with some data, but as it has emerged, they were unaggregated, it was difficult to standardize them, and we will see it through the scheme. If I may go to the first part of the PDF. This is the second one. I would like the first one. Thanks. Okay, if you can zoom, yeah, left upper side. Not that much, thanks. A little bit more in order to understand the initial lines, to read them, if it's possible. To zoom a little bit on the top, left side. And we are trying. So as you can see, yeah, this is the first section, having national models of confiscation in blue and issuing and executing authorities in orange. We will see them better. But going on the blue one, sorry, you see on the top the different modes of confiscation. So we have direct confiscation, value-based confiscation, extended confiscation, non-conviction-based confiscation, civil confiscation, confiscation against third parties, and other freezing or confiscation. Okay, so this is a concentration of all the national reports you send. As you can see, we have put in all the cells of the Excel the references, the legislative references, and as I said, this is for our 10 member states that are the member states of our consortium that join our consortium. This is a comparative, a very quick overview of the state of harmonization of member states, of those member states on confiscation. It is, as the professor was saying, a preliminary result. We have still to work a little bit on amendments, on, trying to make it maybe also on a graphical point of view more appealing. But the sense here is to say, okay, what do we have, what we do not have? And this is the result of, the last 20 years of attempts of harmonization through mainly directives, also framework decisions, national legislation implementing regulation and directives. I'm not going specifically into the details of each column because it would take too much time, but overall we can say that on a legislative point of view, there is a communication between member states on a pretty good level. Of course, there are issues, there are many, many issues, especially on non-conviction-based confiscation and also on confiscation against third parties, but at least I would say the first models are pretty well covered among at least the member states we have dealt with in our project, but we are extending our research to non-partners member states in order to have a complete EU-wide overview of this. On the orange part, we have, as I was saying, the issuing and executing authorities for freezing and confiscation orders. And here again, we have used all the reports and all the information we could collect in order to understand the process that each act had. And here is useful for many, many reasons, for many, many purposes. For example, for an officer to understand what is the process, where he can intervene, and also for policymaking to understand gap and loopholes into the process. If we can go to the second part. Yeah, again, top left on the green side, please. This is splitted into two parts. The green one is about problems and best practices. So we have divided the green part into normative and institutional problems, practical problems, and good party practices. The second part is about data, and we will see it in a minute. But focusing on the first part, this was probably the most demanding part because we had to really try to understand from those multiple sources, have a resume of the problems, of the issues. We have tried our best to identify in small dots, in small information, what were the issues. Of course, as I said, this is a work in progress, but this is extremely useful. Normative and institutional problems relate to, the framework that confiscation is based on in each member state. Practical problems are the practical problems that authorities encounter into the process, and good practices are the good practices that we were able to identify. And we should probably, as it was suggested yesterday, split, problems that are maybe specific to member states and that are EU-wide relevant. We should have some further adjustment on that, and we are trying to investigate and to understand how we could do that. There are many, many amendments and potential things we could implement. So if you have any suggestions, please let us know, and we will implement and also amend this information. Of course, we will disseminate this through our channels and through our website. We have already sent this to our partners. So just please let us know. Overall, there are a lot of problems, but also some good practices. The things that emerged yesterday in our workshop also are, for example, that despite the regulation is an EU-wide instrument, national law needs some tools, some law to translate, to transpose it into the international law, often this so, and sometimes there is an overlapping, for example, with the framework decisions that were in this matter previously emitted, previously approved. but this is really full of practical issues related to the time taken to respond, translation, as we were saying yesterday, but also best practices related to European investigation order, or maybe not, or maybe directly freezing orders, also as we were discussing yesterday. Again, I don't have time to delve into specific issues. I'm just trying to to relate the debate we had yesterday with what we have done, but just please read it in details and let us know what you think about it and suggestions and amendments. Going to data, as we were saying, we really struggled to obtain them. We tried to organize them between confiscation and freezing orders, and in years, we still have to try to find a way in order to understand, to try to signal order recognized, executed, that were refused, and a little bit delve into the issue of refusals and the reasons for refusals. And in general, these are mainly data coming from partners and from the European Commission that gave us very, I would say, disaggregated data, meaning often coming from emails that were saying, oh yeah, we have those orders, we have this number like this, but the potential, the potentiality, let's say, of analytically understand those data is not clear and is poor, because they are really poor data. They don't distinguish usually, often at least, between confiscation and freezing orders. There are problems of time span, because sometimes they're aggregated among years, so 21, 2022, for example. Here we have tried for now to fill just the cells, just the data we were sure about. For example, some partners also communicated as some data that were not maybe fully, that couldn't go into one single cell. So for now, we didn't insert them. We will find a way to do that, and in order to solve this complexity. As an overall picture, it is desolating, I would say, in the sense that if we compare those numbers with the confiscation numbers we have from national reports on a national level, the comparison is unpitiful, I would say, meaning that the numbers are really little. A short number of orders is issued, a little number, I'm sorry, of orders is issued, a little number is recognized, and a little amount of order just end with a full recognition. But this is just the best we could have on this data. I just asked to go a little bit on the bottom. Yeah. Yeah, if you could zoom out a little bit. The problem is that this is a PDF and not the Excel file. Yeah, Germany. Germany is in alphabetical order. For example, Germany, we had those data from the Commission that were related to 2021. Kindly, our representative has provided us with the data related to the overall confiscation in Germany. And here the comparison is, striking, probably, because numbers you have on overall confiscation are really huge, and you are one of the best countries in this respect. But on the side of mutual recognition, you have maybe, as the professor said, Lithuania has a better performance than yours. This is the same with Italy and everything. So it's not to say Germany or Italy or anything, but it's just to say, we have a problem there, and we have to insist on collecting information, on try to, overcome the obstacles that each authority has in our respect, saying, no, we don't have them, no, we don't know, no, we can't, for many reasons. I think this is one of the best thing we can do now, and one of the most important ones. So this is the scheme. This is pretty much all, I would say. Thank you.
Okay, thank you so much, Matteo. Now, I hope that Paolo Albuquerque, who is a professor of criminal law in the Catholic University of Lisbon and former judge of the European Court of Human Rights, is connected for his presentation about the jurisprudence of the European Court of Human Rights about confiscation without conviction. Judge Albuquerque, no, okay, maybe later. So I suppose that he had some problems because he told me that he was connecting. So maybe I can start when he's ready. I can stop my presentation and carry on after. Yes, when he is connected. No, no. So no, there was because he had a problem because after he should do his lesson lecture in the university. So our agreement was 9:30, but I don't know. Maybe he had problems.
Should be another time zone.
Okay. Okay.
It's raining.
No, maybe it was in the traffic, but I don't know. In any case, I ask another time, but we can. Okay, I can start with my presentation. It is not a problem. Okay.
Yes.
Okay, thank you so much. So, one of the first problem that we try to face is, first of all, which is the scope of the regulation. It is a fundamental instrument for the mutual recognition of a freezing and confiscation order. The aim of its introduction is, first of all, to improve the mutual recognition, to provide simple, faster procedure and certificates, to increase the number of victims receiving cross-border compensation. It is important to remember that this instrument replaces the provision of framework decision 577 of 2003 and above all, the framework decision 783 of 2006 about mutual recognition of a freezing and confiscation order. The adoption of this regulation is a very important event for two reasons. First of all, because this principle of mutual recognition is affirmed in this delicate sector, confiscation, and because it's imposed with a directly applicable legislative measure such as a regulation, adopted with the ordinary legislative procedure on the basis of Article 82, paragraph 1 of the Treaty on the Functioning of the European Union. This is stressed also in the recital 11, in order to assure the effective mutual recognition. The use of the recognition and execution of this order should be established by a legally binding and directly applicable acts of the Union. This means that also the states that don't have some models of confiscation have to apply. The choice of the regulation of a regulation is appreciable in terms of effectiveness because it is directly applicable, but is also a bit problematic because this approach ends up attributing a direct competence in criminal procedure matters to the European legislator in the absence of a more explicit and clear legislative will of the member states in this direction. This choice assumes a strong political value. Even if it involves only the cooperation and not the harmonization demands a directive. The mutual recognition that is apparently unrelated to substantive issue however, ends to exercise a drag effect on substantive issue. This is stressed by recital 13. While such orders might not exist in the legal system of a member states, these member states should be able to recognize and execute such an order issued by another member state. Yesterday, we faced the problem of in Romania, the Constitutional Court would not recognize the extended confiscation in relation of facts before the introduction of extended confiscation in Romanian. So this is the application of the principle of retroactivity, but it is not consistent with the rules of the regulation. The European legislator is so aware of this strong political value that it has established in recital 53 that the legal form of this act should not constitute a precedent. Okay, the regulation should cover all crimes, also crimes which are not considered in Directive 42 of 2014, that is the instrument for the harmonization of a prisoner confiscation order in Europe. This means not only to serious transnational crimes, the so-called Euro crimes. This is also stressed in recital 14. And it is important to stress that in Article 3 of the regulation contains the list of a serious crime punished with a prison sentence of at least 3 years for which verification of the double criminality of the fact is not required. On the same model of the framework decision 584 of 2002 on the European arrest warrant. I stress this aspect because speaking with some prosecutor, Italian also prosecutor, this is not so clear. In the case of offense not included in the list, only in this case, recognition can be refused if the predicate crime is not a criminal offense in the states that has to execute the measure. The regulation has some rules about the recognition, first of all, of the seizure, the freezing order, seizure order, which can be ordered by a non-judicial authority, but the regulation demands that the freezing order should be validated by a judge, court, or public prosecutor, a judicial authority. However, it is not required that any freezing order seizure pronounced by the public prosecutor should be validated by the judge. It would be better, in my opinion, but maybe I have a judicial approach. The idea that it is always better, no, that a validation of the judicial authority. All types of confiscation order within a framework of criminal proceeding are included, not only the models of confiscation which are covered by the directive. This means direct confiscation, confiscation of the value, extended confiscation, confiscation of assets in the possession of third parties, non-conviction-based confiscation, and not only in case which are included in the directive, in Article 4 of the directive. This means in case of absconding or illness, but also types of orders issued without final conviction, which are not included in the directive. Recital 13. Other types of order without final conviction. Also in the explanatory memorandum, it is clarified which are this case, the case of the death of a person, immunity, prescription, cases where the perpetrator of an offense can't be identified, or other cases where a criminal court can confiscate an asset without conviction when the court has decided that such asset is the proceeds of a crime. This means action in rem, a pure action in rem. Regulation doesn't demand that a criminal trial has begun, but the sentence cannot be pronounced. This is the case which are regulated in Article 4 of the directive and in Article 15 of the new proposal of a directive. Action in rem is more, is action in rem is more similar to the model of confiscation of unjustified wealth that is now in the Article 16 of the new proposal of a directive. Even if also in that case there are some limits, or for example, only in the sector of the fight against organized crime. And okay, but the most important aspect of this presentation is what means, which is the scope. The scope of the regulation is lays down the rules under which a member state recognizes and executes in its territory freezing order, confiscation order issued by another member state within the framework of proceeding in criminal matters. What means proceeding in criminal matters? In the original version of the regulation, in order to be included in the scope, this type of confiscation should be pronounced in a criminal proceeding. This means with all the safeguards of a criminal proceeding. The change of expression was the outcome, the result, first of all, of the pressure of the Italian delegation. This is also recognized in public documents of the Council of the European Union, interinstitutional, because the fear of the Italian delegation is that criminal proceeding doesn't include the so-called preventive confiscation, the Italian model of non-conviction based confiscation. Also, during the meetings of the Working Party on Judicial Cooperation in Criminal Matters in the September of 2007, some member states accepted this modification, but other member states, for example, Germany, had some doubts about this extension of the scope of the regulation. Some doubts in terms of the respect of the safeguard of the criminal law. The Italian delegation assured that our models has many safeguards, is in any case a judicial model, is a criminal judicial model, because it's recognized as a model of a proceeding, a kind of executing proceeding in the criminal law. In any case, the presidency invited the Council Legal Service to give his opinion. In this opinion, in any case, this was recognized. So the presidency considers that this decision on the extension was a political decision. In the end, this expression was accepted. And also in these other official documents, in this debate amongst European Ministers of Justice, it was recognized that the regulation can cover also preventive confiscation. So what means proceeding in criminal matter? Proceeding in criminal matter is an autonomous concept of a union law interpreted by the Court of Justice. This reference to the Court of Justice is very important because the adoption of a regulation in a more direct and immediate manner call into question the Court of Justice on the basis of Article 267 of the Treaty on the Functioning of the European Union. The Court of Justice is the interpreter in his original capacity. Proceeding in relation to criminal offense in the recital 13 is considered a proceeding in relation to a criminal offense. Also in Article 2, in the definition of confiscation, the confiscation is a final deprivation of property ordered by a court in relation to a criminal offense. So, in the end, proceeding in a criminal matter means proceeding with a link to a crime, with a connection with a crime. So means proceeding related to the profits or the instrument of offense. Also adopted without conviction, also including certain preventive confiscation system. What is important is this connection with a crime, with the profits or instruments of offense. In the recital 13, also in this concept of proceeding criminal matter are included also criminal investigation by the police and other law enforcement authorities. This is not acceptable in my opinion in view of law because in any case seizure and confiscation are a form of limitation of a citizen's right, the right of property, Article 1 of the Protocol 1 of the European Convention on Human Rights, Article 17 of the Charter of Fundamental Rights. And also in Article 2, number 2 of the regulation, refers to a measure taken by a judicial authority. A confiscation should be a measure taken by a judicial authority. No civil or administrative proceeding. This is affirmed in Article 1 of the regulation in the recital 13. What means civil administrative proceeding? In my opinion, and I hope in our opinion, should be excluded from the scope of the regulation only form of confiscation which are not involved in criminal offense. Confiscation for extend a street in a city, no, for civil scope, non for in relation with crimes, with proceeds or instrument of crimes. Okay, there are always some concern about this concept of proceeding criminal matter because in the practice in different member states, countries, we have different kinds of proceeding which are possible to define hybrids. They are held before the criminal court but without the safeguard of the criminal matter. Or they are included in civil or administrative matters, but they fall perfectly in the definition of a proceeding in relation to a criminal offense because they relate to the proceeds or instrument of offense. The model in the explanatory effort of the first version of the regulation was stressed that the model adopted by the regulation is the German confiscation without conviction. It is a model of non-conviction based confiscation on paragraph 76, paragraph 4, and is a real action in rem. Based on all circumstances of the case, the court is convinced that an object is the proceeds of a crime, even if the person affected by the confiscation can't be prosecuted or convicted for this crime. Also in Strasbourg Convention of 1990, that was the most important instrument for cooperation before the regulation in the praxis, it is recognized that proceeding extended the concept of proceeding criminal matter in the meaning that proceeding covering instrument of proceeds of a crime. The problem, other problem, which are the safeguards, because the regulation demands had adopted a so extended the concept of proceeding in criminal matter, but demands the safeguards of a criminal matter in the member states. In the Article 1, it is affirmed that this regulation shall not have the effect of modifying the obligation to respect the fundamental rights in Article 6 of the Treaty of the European Union. Is specified in recital number 17, The regulation also respects the fundamental rights provided for in the European Convention of Human Rights and the European Charter of Fundamental Rights. This means, first of all, Article 49, 50 of the European Charter of Fundamental Rights, Article 6 and 7 of the European Convention of Human Rights, and also in the recital 18, it is stressed that the procedural rights set out in several directives, procedural about procedural rights, should be recognized. In particular, the directive about the presumption of innocence. In this directive is recognized that it is possible to use presumption also in criminal law. What is important is that these presumptions are rebuttable, is recognized the right of defense. But also on the basis of the directive, the right to silence. Many of these models recognize some evidentiary value to the science. In any case, what are the important aspect in the recital 18, it is stressed not only that the procedural right recognized in several directives, but all the safeguards of the criminal matter, the safeguards under the Charter, should apply to all proceedings covered by this regulation, in particular the essential safeguard for criminal proceedings set out in the Charter should apply to proceeding criminal matter that are not criminal proceedings, but which are covered by this regulation. So, the essential safeguard of criminal matter. Which are these essential safeguard? I think that first of all, we have to recognize the safeguards which are recognized in Article 8 of the directive. Effective remedy, fair trial, adverse judicial proceeding. The guarantee of a means of appeal against the recognition and execution of a confiscation decision are recognized in Article 33 of the regulation. Article 8, number 8 of the directive specify also that the affected person should have an effective possibility to challenge the circumstance of the case, in particular, specific fact and available evidence on the basis of which the property concerned is considered to be property that is derived from criminal conduct. This means the right to demonstrate the legal origin of the assets. This means that notwithstanding the directive allows presumption, Article 5, the standard confiscation and recital 21, it does not prevent member states from providing a more extensive power in their national law also, but there is an unbreakable limit. Confiscation cannot be based on absolute or irrebuttable presumption, which prevent the defendant from proving the non-criminal origin of property. In recital number 15, it is also recognized that the principle of mutual recognition demands mutual trust, and so the decision will be recognized and executed in compliance with the principle of legality, subsidiarity, proportionality, and the right of third parties in good faith. There are many rules about the protection of third parties in the directive, but also in the regulation. Other important element. There is a ground for refusal in the Articles 8 and 19, 8 for the freezing order, 19 for confiscation order. One of these grounds for refusal is the manifest breach of a relevant fundamental rights as set out in the Charter. For the first time in an instrument of cooperation, a manifest breach of fundamental rights is recognized as a ground for refusal. This means right of effective remedy, the right of a fair trial, the right of defense. we have to remember that this list differs significantly from the list contained in the framework framework decision of 2006 because the ground for refusal linked to the type of the confiscation order have not been included. I think to the debate of yesterday about the no recognition of extended confiscation in Romania. So, in the hybrid confiscation proceeding of the member states have to respect the safeguard of the criminal matter in order to apply the regulation. It is important to verify if the confiscation is adopted in a proceeding criminal matter with the connected safeguard. The regulation represents a challenge to provide for a complete jurisdictionalization within the criminal law. Okay, in Italy, the traditional format, there are no problem are included. Also the extended confiscation, because this model is included in Article 5 of the directive, even if is more severe, is normally applied in a criminal trial by the judge of the cognition. There are some doubt about the case when it is applied in the enforcement procedure. It is sure that is included in the concept of a proceeding criminal matter because is included in this is a proceeding connected with a criminal offense, but there are some doubts about the safeguards because the confiscation is allowed to be pronounced in audita altra parte. It is not possible to appeal, but only to recourse. It is allowed to pronounce, the power of the enforcement judge are residual powers. It's also possible to apply after prescription or amnesty. And also, Italian preventive confiscation is in any case applied in a proceeding in relation to an offense. It must represent considered social danger because it is a suspect of a criminal activity. There are circumstantial evidence of a criminal activity. Confiscation are the set of a criminal origin because there are circumstantial evidence of this criminal origin or because the value is disproportionate. So in any case, is a proceeding connected with a criminal offense. It's also in the opinion of the Italian desk of Eurojust is included in the regulation, also in the circular of the Italian Ministry of Justice. Okay, to conclude, is it possible to adopt the concept of a criminal proceeding criminal matter, which is used by the European Court of Human Rights, which is a very extended concept of criminal matter, is on the basis of the Engel criteria for establishing the criminal nature, the official formal qualification, the very nature of the infringement, the nature of a sanction, the degree of a sanction severity. In his case law, European Court of Human Rights has substantially excluded the inclusion in the notion of criminal matter of the proceeding for the application of a form of confiscation without conviction. Italia preventive confiscation, British civil recovery, or the civil recovery in civil forfeiture in Georgia, and so on. In the recital 13 of the regulation, it is established that proceeding criminal matter is an autonomous concept of the Union law, notwithstanding the case law of the European Court of Human Rights. Notwithstanding has an adversarial meaning. Even if in the Italian translation, the expression used without prejudice is inclusive, not adversative. In any case, in the English version, that in my opinion is the original version, the true version, is notwithstanding. The European legislators seem aware that in European Court Human Rights case law, the different forms of extended and non-convictional based confiscation are not included in this concept. Okay, I don't have more time. There is a big debate in the academic in academia and doctrine about this the idea is that by many authors, also this is the position of of the Judge Albuquerque, that these instruments are included in the extended concept of a criminal matter of the European Court of Human Rights. But what I would like to stress in the end is that in any case, also if the European Court in many in some decision has affirmed that this instrument have compensatory nature, it is possible to adopt the reverse of the burden of the proof or a civil standard of the proof. In any case, in the more recent decision, Todorov case, Balsamo case, and so on, the court recognized the correctness of the procedure that led to the assessment of the lawful origin of forms of extended confiscation, also in the light of Article 5 of the directive, only when there is a real effort to ascertain a link between proceeds and criminal activity, in the absence of which the confiscation represents a disproportionate sacrifice of the right of ownership. Is possible to give this evidence with presumption, by presumption, but in any case it is necessary to demonstrate this link. In some cases, in Todorov and other cases, the Court of Human Rights convicted the country because not the wide scope of the governing acts in this case, in terms of the offense that could engage its power, and the length of time that could pass before proceeding being brought, could present difficulties for applicants, and that this advantage for the states has to be counterbalanced by an obligation to show some links to actual criminality in the provenance of the assets to be forfeit. So the importance of the evidence about the legal origin. In my opinion, in opinion of many authors, for example, Colin King, it would be better that even if we have forms of confiscation without conviction, but in any case, the standard of the proof has to be a criminal standard of the proof, because in the end, in a rule of law, it would be better get the forfeiture of property, the forfeiture of property of asset in rule of law without conviction can be justified only with this proof of the legal origin. Okay. Maybe too long. Thank you so much. And if we don't have, no, okay. So we, I hope that we can have the presentation of the Judge Albuquerque after. Now, non trovavo il link. No, non lo so. Sì. Aspetta, lo mandiamo qui? Sorry, a moment. Invite. Ok.
Ce l'ha?
Gliel'ho mandato, io gliel'ho mandato. Ok. L'ho mandato, giusto? Okay. In any case, we carry on with our connesso. No, okay, okay. Okay, we carry on with our program with Dr. Fini, Judicial Authority Judge, a member of the Italian Ministry of Justice. His presentation is about the mutual recognition of freezing orders and confiscation, and in particular about the proceeding in the praxis for the mutual recognition. Please, I give you the floor.
Good morning, everyone, to people who's attending here the seminar, but also to people connected remotely. I'm Michele Fini. I'm a part of the Italian judiciary. I've been working as a public prosecutor at the Naples Prosecution Office for 15 years, and now I'm seconded at the Ministry of Justice since March 2018, dealing with mainly international judicial cooperation proceedings. I will give you today only a brief and short overview of the procedures for the starting off with the transmission of the freezing and confiscation orders, and ending up with possibly the recognition and execution of the order themselves, or when this is not possible, with the refusal or even the postponement of the said recognition and execution. It's really, due to time constraints, a brief overview, but please feel free to interrupt me if there is something you are interested in. Yeah, of course. Okay, we'll do it later. No, it's fine. It's fine. Yeah.
We can start with the judge. Real sorry. Maybe we can start with Paolo Albuquerque, because I know that he couldn't after. Okay?
Can you hear me?
Yes.
Anna Maria, can you hear me?
Yes.
Okay.
Thank you so
I'm
much
sorry.
for your presence here. I would stress that for us.
Sorry to interrupt.
Yeah.
I'm sorry to interrupt the colleague. I'm really sorry, but I have other commitments, so I will be brief. And just to update you on the main aspects of the ECHR case law on this issue of confiscation, and particularly on the issue of confiscation of assets of third parties. You may be aware that the case law has dealt with this issue from three different perspectives. Article 1 of Protocol 1, so the right to property, Article 6, the right to a fair trial, and Article 7, the principle of legality in criminal affairs. So these are the three main articles of the convention and the first protocol that are invoked in confiscation cases at the Strasbourg court. Let me start by mentioning the first one. The main concern here is the fact that Article 1 of Protocol 1 refers to two different types of intervention, of state intervention, and they are mentioned in the first paragraph: deprivation of possessions, and the second, control of the use of possessions. Why is it so important to classify confiscation as a deprivation or as a use of property, a measure of use, of control of use of property? Because the margin of appreciation of the state is different. The margin of appreciation of the state is much narrower in the case of deprivation of possession. So if you classify a measure of confiscation as a measure of deprivation of possession, the margin of appreciation of the state is much narrower. Okay? If you classify the measure of confiscation as a measure of control of use of property, then the margin of appreciation of the state is much larger. Okay? And we have cases in the case law of the court for the two different approaches, very different approaches, yet you can find cases where the court has used the first paragraph of Article 1 of Protocol 1, so classifying confiscation as a measure of deprivation of possession. And you have also different types of cases where the court has used the second paragraph of Article 1, Protocol 1, classifying confiscation measures as measures to control the use of property. You have to be very attentive to the language and the grounds that are used, the legal grounds that are used by the court when dealing with cases of confiscation. Either Article 1, Protocol 1, first paragraph, much narrower margin of appreciation, or Article 1, Protocol 1, second paragraph, then much larger margin of appreciation. In the casuistic of the case law of the court, you find, of course, confiscation of productum celeris, cases such as, for instance, Gogitside versus Georgia. You find cases of confiscation of objectum celeris, for instance, Agossi versus United Kingdom. And you find cases, of course, of confiscation of instrumentum celeris. Service bans versus Romania is such an example. But you also find cases where there is no connection between the confiscation measure and the practice of a crime. Okay, for instance, Todorov versus Bulgaria. With regard to third parties, so confiscation of third parties, people that are not accused or in any way involved in the crime, you have four different types of cases. So non-conviction based confiscation can be divided in four different types of cases in the case law of the court, in the practice of the court, in the praxis of the court. Four different types of cases. This has been referred to, these cases, and this type of cases, different types of cases have been referred to in my separate opinion in Varvara versus Italy. You can read that, of course, followed by the separate opinion in GM versus Italy. So the first group of cases of non-conviction based confiscation cases are cases where the order of conviction, of confiscation, is given within the procedure, within a criminal procedure, and is imposed on third parties that are not subjects of the procedure. For instance, GM. But there are many others. Rumi versus Estonia, Vates versus Estonia, Silikieni versus Lithuania, many others. The second group is the case where the confiscation order is imposed on the acquitted person. The person has already been acquitted, so he has been accused and he has been acquitted. So he is considered as a third party because although he has been an accused person, he has been acquitted already, or the procedure has been dismissed against him for any other reason, procedural or substantive. But then this confiscation measure is taken after the acquittal or the dismissal of the case. Okay, here you have Balsamo versus San Benito, Gerings versus the Netherlands, Saliba versus Malta, Raimondo versus Italy. The third type of cases, I'm always talking about non-conviction-based confiscation. Okay, the first type of cases of such NCB confiscation cases is the group of cases where confiscation is ordered in an administrative or civil procedure. Okay, but it is imposed on people suspected of having practiced the crime, of having been involved in a crime. Okay, confiscation orders imposed in an administrative or civil procedure, but imposed on people that are suspected for some way, for some reason, or in any possible way of being connected with the commitment of the crime. Here you have Walsh versus United Kingdom, Webb versus United Kingdom, or Butler versus United Kingdom. So confiscation imposed on in administrative or civil procedures on people suspected of having committed the crime. Fourth and final type of cases, always talking about non-conviction based confiscation. It's the order of confiscation given in an administrative or civil procedure imposed on third parties that are in some way related to a person suspected of having committed the crime. So the third party is himself or herself not suspected, but he or she is in some way related to someone who is suspected of having committed the crime. Here you have Cacucci versus Italy, Bongiorno versus Italy, Perre versus Italy, Morabito versus Italy, Riella versus Italy, Arcuri versus Italy, many Italian cases. Just to sum up, when the court uses Article 1, Protocol 1, the main practical consequence is the fact that it imposes the principle of legality, okay? According to the Article 1, Protocol 1 provision, these measures of deprivation or control of use of property, they are to be regulated according to the principle of legality, which means that they cannot be imposed retroactively. This is the most important practical effect. Let me pass on very rapidly to Article 6. Article 6 has been used by the court to control the compatibility of the national procedure of confiscation with the standards of the court. Here, the court uses the Engel criteria and sometimes finds that the measure has a civil character, and sometimes it finds that the measure has a penal character. The guarantees are totally different. If you find that the measure is only civil, then only 6.1 applies. If you find that the measure has a penal character, then 6.2 and 3 also apply. Okay, it's extremely important to classify correctly the measure. And here the case law of the court varies a lot. When the court finds that the measure is penal, it applies not only the guarantees of 6.2 and 6.3, but also Article 7. Extremely important. The principle of legality fully applies as if it were a measure of criminal nature. And this occurred in Sudfondi versus Italy, and also in GM versus Italy. So the measures were assessed under Article 7 because the court found that they had a penal character. Now, just a brief remark on the application of Article 6 and 7. The guarantees of these provisions can apply fully when the person that has been targeted is accused of having acquired the property in bad faith. This concept is extremely important in the case law of the court. This bad faith concept has been used by the court in order to justify the measure of confiscation of property of third parties. Okay, third parties can be targeted if they were in bad faith when they acquired the property. Now, what is bad faith for the convention? What is the concept of bad faith for the convention? There are a couple of very important cases, but the most important ones are Air Canada versus United Kingdom, and all the series of case law based on Air Canada. Here, the court has a very wide concept of bad faith. It does not only include dolus, but also negligence. So if the third party acquired property in dolus, with dolus, there's no doubt that there is bad faith. But also in the cases like in Air Canada, where there was mere negligence, the court concluded that there was sufficient bad faith in order to justify the measure of confiscation of property acquired by third parties. This is extremely important, okay? Because it enlarges the scope of bad faith to negligence acquisition of property. So when the person is supposed to control the legality of the property that he or she is acquiring. Here, there's also a very important caveat to make. And the caveat is that, and this comes from the Russian cases, very Belova versus Russia, Lentseva versus Russia, Zielinski versus Lithuania also. Zielinski is not Zielinski, the president, of course, it's another Zielinski. But these cases, the courts stated that when there are errors, serious errors or mistakes committed by state agents, they should not affect the position of the third party. So the third party who acquires property based on errors committed by state agents should not pay the price for that error, okay? Even if the third party is in bad faith. This is extremely important because the error of the state agent covers the bad faith of the third party. This is extremely important. So the bad faith can be cleaned if there is an error, a clear error on the part of the state agent, which is responsible for the acquisition of the property by the third party. Finally, and coming to the end of my very brief presentation, what are the means of protection of the rights of third parties? So we have seen that the third parties can be targeted when they are in bad faith. Where are the means of protection of third parties? Here, of course, GM is the most important authority. The court says, again, in GM, the very important paragraph 139. Read 139 of GM, the Grand Chamber case against Italy. It's extremely important. It says that confiscation measures should not target third parties unless they are in bad faith. Well, what are the protections, the procedural protections of these third parties in bad faith? Because although they have a bad faith, although they are being targeted and they can be targeted, they have rights under the Article 6, and they can of course invoke the rights of Article 6 6.1, 6.2, and 3, because this is, in the vast majority of cases, a measure of penal character. So the most important procedural right established in Silikien versus Lithuania is the right of the third party to intervene in the procedure. Although the third party is outside of the procedure, that's why it is a third party. The most important procedural right that the court acknowledges to third parties is precisely the right to intervene in the procedure as a subject, okay? It should have all the rights, all the procedural rights of a formal subject in the criminal procedure. Silikien versus Lithuania, read the paragraph 50 of Silikien, okay? So you have to award the status of a fully acknowledged party to the procedure. Although it is third party, it should be acknowledged fully as a party in the procedure in order to defend himself or herself. Otherwise, if it is not acknowledged as formally as a party with all the rights, including appeal rights, everything that is attached to the status of a party, then there might be a violation of Article 6. Okay, there might be a violation of Article 6 because there were not enough guarantees, procedural guarantees, awarded to this third party. This has been confirmed in many cases: Vates versus Estonia, Telbis versus Romania, Marcos versus Lithuania, Rumi versus Estonia. So various consequences that are drawn from this acknowledgement of the formal status of a party given to a third party. For instance, the right to a decision which is grounded and notified to the third party, okay? The right to present witnesses, the right to explain the origin of the instruments and the products and advantages that have been targeted, the right to present arguments before an appellate court, the right to have a lawyer. All these rights must be acknowledged to a third party, all of them. Otherwise, according to the case law of the court, there is a violation of Article 6. I can give you a long list of case law: Marcos versus Lithuania, Silikiani versus Lithuania, Telbis versus Romania, Vates versus Estonia. All of these cases are cases of confiscation of third parties, goods of third parties, assets of third parties, where there was a violation of Article 6 because the third parties were not acknowledged the status of a party. They had not been given the rights and the guarantees of a party in the criminal procedure. Okay? Then finally, of course, the right, the most important right, the right to submit evidence. I refer to witnesses, but not only witnesses. In general terms, evidence. Yildirim versus Italy. Important case, a decision, not a judgment, a decision. Yildirim versus Italy from 2003, where the issue was about exactly this right to submit evidence that the third party finds important to defend himself. This is the most important case law of the court. Very briefly presented. I'm again asking for your indulgence because I have other commitments. I'm sorry that I could not come to Italy. It's always a pleasure to come to Italy, especially on invitation of Anna Maria, a great friend of mine. I would have loved to come to Italy, but for several reasons, including health reasons, I could not come this time. Maybe next time there will be this follow up to this meeting, and I will be in a position to come. Thank you for your attention, and sorry again for interrupting the colleague.
Thank you so much, dear Paolo, for your important contribution to our project. It is very important, in my opinion, which I also in our project, to stress the importance of the safeguards and try to understand which are the essential safeguards which we have to guarantee in this also in the application of the regulation. So it is important, in my opinion, try to valorize the case law of the European Court of Human Rights in order to improve the safeguards in the application of the regulation. Sometimes the European Court is not always so consistent with also the convention. In my opinion, there are different positions. Sometimes it is not clear because why if for a form of confiscation is recognized that is included in the concept of criminal matter, and in other case no. Okay, sometimes there are differences between the confiscation of the instrument and confiscation of the proceeds for the crime. But in any case, in the extended concept of confiscation of criminal matter, in my opinion, in the opinion of a judge Albuquerque, many of these proceeding without conviction have to be included in this extended concept with the guarantee of the criminal matter. Thank you so much, dear Paolo, for stressing so the different position and the different safeguards connected with the different model in the position of the European Court. And we hope that next time you can be with us in presence. And now I give the floor to Dr. Michele Fini, and I am sorry again for interrupting you before.
Mr. Fini, sorry, on behalf of Università Cattolica, we apologize for having interrupted you. So this is not our style in doing things, so please consider these things.
I'm really totally fine. I had just begun, so.
Cattolica, the speaker is interrupted.
I'm sorry. Anna Maria?
Paolo.
I'm sorry. I'm really sorry. I did not want to hurt the feelings of anyone. I just want to make that clear to the colleague who was speaking and to the chair who just left the table. I'm also a professor at the Catholic University, and of course here in Lisbon, and of course I did not want to hurt anyone's feelings. I'm really sorry for that. If you felt
don't worry, Paolo. Don't worry.
Sorry.
In any case, the responsibility is mine, but I decided to do so because it was the best solution now for our program. Yeah. Don't worry.
Okay, sorry.
Thank you so much.
Just want to make sure that no one thinks that I felt hurt, but I can understand all the issues coming up. But I want to make Professor Savona and also the colleague, but Anna Maria, that so if I had just begun, so it was not really an interruption. So resuming the presentation, I was just saying before starting off, actually, that it would be a brief overview, and of course it has been arranged due to constraint of time around some main points, but of course regarding the underlying issues that we are perfectly aware stands out of every single point. Feel free to interrupt me either while talking or at the end of presentation. So I think it's very important in order to outline, to show off how the regulation outlines the procedures, starting from transmission and ending up with recognition and execution. Recognize that it is actually a procedures like the other, inspired by the principle of mutual recognition. It responds to criteria and scansions typically of those cooperation procedures. The principle of mutual recognition implies a general unconditional recognition of decision pronounced by the national judicial authorities of member states of the European Union, with the consequence that the executing authority, the competent authority of the executing state, is called upon to recognize and execute a decision with minimal formalities and may refuse recognition and execution only where one of the limited and expressly provided reasons for refusal does exist. And this is the very first step we have to take in order to reach the wider implementation of the regulation that we are pursuing also with this project, because this is the precondition of all the efforts we can be doing in order to achieve that goal. First element to be taken into consideration while going through the procedures outlined by the regulation is, of course, the certificate. It's something which we have already stumbled across within other judicial cooperation instruments, European arrest warrant, EIO lately, but even in the middle, the transfer of sentenced people. So this is a model, this is a way which has already been used and implemented during the years in the adoption of international judicial cooperation instruments by the European Union. The certificate has to be signed by the issuing authority. It has to be translated at the stage. We have been discussing about the possibility to accept English yesterday, but we are also likely to be relying in a couple of years in IA semi-automatic, at least, translation systems. But anyway, at the current stage, it has to be translated and according to the regulation, of course, into an official language of the executing state or also into a language accepted by the same state. It has to be transmitted, sticking to the words, to the wording used by the regulation, in a way which permits to keep a written record and which allows, on the other hand, the executing authority to ascertain its authenticity. It has to be filled in with all the information necessary for the recognition and execution of the freezing or confiscation order. And taking advantage of this point, I can introduce a substantive issue. The necessity to fill in the certificate with all the information necessary means also that the issuing authority has to give, especially with the more problematic models of confiscation, all the information which are on a substantive field necessary to recognize and execute the order itself, and namely the confiscation order, above all the non-conviction based confiscation order. The general rule is that only the certificate has to be forwarded to the executing authority, but there is also, according to Article 4, Para 2 and Article 14, Para 2, respectively, for freezing and confiscation, the possibility for the member states to issue a declaration with which they ask to receive also the freezing, the national decisions of the freezing and confiscation, the national freezing and confiscation order. Italy did give this declaration, so as it comes to Italy, we want to receive, along with the certificate, also the national decision. When it comes to Italy as an issuing state, of course, we will have, in this case, the Minister of Justice gives its support to Italian judicial authorities to verify whether the executing state has made such a declaration or not. The main important section of a certificate are the section D or section E and F, which regards the information to be given regarding the asset to be frozen or confiscated, and particularly the connection when it comes to section D with the crimes committed, the statement that the asset is proceeds of crime or is an instrument of crimes, or the different hypotheses set out in this section. And again, section E and F for freezing and confiscation, which can also be the base for what I've been saying about the provision of all the possible information to the executing authorities. And that's what I've been talking about yesterday, about connecting to this necessity to give all the information, all the possible information to be used for recognition and execution, about the certificate, but mainly about the circular we issued at the Italian Minister of Justice regarding the whole regulation, actually, but in this case, the part related to the no conviction-based confiscation. We suggested that we I wouldn't say push, but anyway, we made it clear with our judicial authorities that as this is, of course, as we have been saying also yesterday and today, a model provided for by the regulation, but with sensitive differences between the different member states, something which has to be presented in a proper way to the other member states, especially to those which do not use it or do not know it, like yesterday we've been saying with the Romanian colleagues. And so this is translated into English what we have told them to put in the certificate while sending us to be forwarded to the executing authority. We can read it. I can read it out. The seizure confiscation measure, and we are referring here to the no conviction-based confiscation, transmitted was adopted pursuant to legislative decree number 159/2011, which is the consolidated text of laws against organized crime in Italy, which provides for the seizure and subsequent confiscation, not necessarily based on a conviction, of assets that are believed to be the proceeds of criminal activity. So there is a connection of crimes, or assets purchased with the proceeds of such a criminal activity. So still even a lesser connection with crimes. In particular, it is envisaged that assets in the direct or indirect, and we are referring here at the issue of a beneficial owner, of individuals who are suspected of having committing serious crimes can be first sides and they are confiscated. So there is also a connection between individuals and crimes, apart from assets and crimes, when the value, and this is the not precondition, but as I said yesterday, just a part of the whole, when the value of such asset is disproportionate to the income or economic activity carried out, the so-called, what we have called yesterday, the unexplained wealth, as well as when such goods are found to be of illicit origin or constitute the reuse of illicit profits. I have to add also that as to the unexplained wealth, that there is still at the very end, until the very end, for the defendant to explain in his her own way the disproportionality. So apart from what emerges from the files, the paper files, it has still this. They have still this opportunity in order to avoid the confiscation. Likewise, it's envisaged that assets in the direct or indirect availability of individuals in relation to whom, this is the second category. in relation to whom it must be considered on the basis of specific circumstances, including the confirmed previous commission of crimes, that they habitually live, at least in part, with the proceeds of criminal activities. So still, in this case, a connection with criminal activities, not as to their commission, but as to the living with the proceeds of them. Maybe first sides and therein confiscated when the value of such assets is disproportionate to the income of economic activity carried out, as well as when the assets themselves are of illicit origin or constitute the reuse of illicit profits. This part is, of course, it's the same regarding the same of the one regarding the first category. Of course, you can find the whole circular apart from this part on the website of Ministry of Justice. But please, if you are interested in, let me know, and we'll send you the official PDF file. Procedures. As we have been saying at the beginning, the underlying principles, it's the principle of mutual recognition. It is well highlighted also in para 1 of both Article 7 and 18, which state as follows: the executing authority shall recognize the freeze or confiscation order transmitted in accordance with Article 414 and shall take the measure necessary for its execution in the same way as for a domestic freezing or confiscation order issued by an authority of the executing state. This is the key meaning of, in this case, of the principle of mutual recognition. Unless, as we've been saying before, but only unless the executing authority invokes one of the grounds for non-recognition and non-execution provided for in Article 8:19 for freezing and confiscation, or one of the grounds for postponement provided for in Article 10:21. I would say a logical follow-up of this provision is that the one that is outlined for both freezing and confiscation in para 2 of Articles 8 and 19, which called for mandatory consultation, call on the involved authorities, both issuing and executing, but the stress is, of course, on the executing authorities before refusing or postponing the recognition or the execution, to start out the consultation with the issuing authority in order to possibly solve the issues which have come up. So in any of the case referred to in paragraph 1 of Article 8 and 19, when the executing authority deems that grant for refusal actually occurs, before deciding not to recognize or execute the freezing or confiscation order, whether wholly or partially, the executing authority shall consult the issuing authority by any appropriate means, and where appropriate, shall request the issuing authority to supply any necessary information without delay. This is also a pretty consolidated provision, but we have to remember it, especially when it comes to instruments that in our national experience we do not know, because that's the field where supplementary additional information may help out even more. So we have already recalled them. They are the grounds for recognition and execution would have to be the only cases in which the recognition and execution do not have to take place. I will recall them very, very shortly. Nebis in idem is the letter A of both Article 8 and Article 19. Privilege or immunity under the law of the executing state. We can notice there here that along with the wording used in the previous framework decision 2003 and 5, there is also a specific addition concerning the freedom of express and generally talking the freedom of expression. The letter B, certificate incomplete or manifestly incorrect, letter C. Again, letter D, and so far we are talking about grounds for not recognition execution, which apply to both freezing and confiscation. This applies also to letter D, which regards criminal offense committed wholly or partially outside the territory of the issuing state and wholly or partially in the territory of the executing state, but only whether the conduct in connection with which the freezing and confiscation order was issued does not constitute a criminal offense under the law of the executing state. Then let's come to letter A, which regards the rights of bona fide thirds, which applies only for confiscation. We can notice here, it's outside the slide, but it's for me important to stress this out, that this is not the wording bona fide thirds used by the regulation. It refers to people affected by the orders, and it is clearly stated that people affected include the person against whom the order has been issued, but also the person who actually holds the possession of the good at that moment. And of course, the rights of people acquired on the same goods, and we can add with good faith, which, as our colleagues just explained, according to the judgments, the more recurring judgment of the European Court of Human Rights, does not include hypothesis where dolus or negligence recur. So bad faith is a bit wider than good faith. Then double criminality, E for freezing, F for confiscation, which of course is not applicable for the so-called Euro crimes listed in Article 3, Para 1 of the regulation. Still only for confiscation, and I have to add only for confiscation based on conviction. Letter G, decision in absentia. Regarding this ground for refusal, I want to just stress that as we also pointed out in our circular, this is applicable only for confiscation based on confiscation for the wording expressly used by the European legislator, which refer in this letter only to the conviction based on a conviction, which is on the one hand a further confirmation that the regulation is referring also to the conviction not based on to the confiscation not based on conviction, but it has also to be I would say it has also to be added that this does not mean that the proceeding regarding confiscation not based on conviction does not have to be fully to be anyway implemented with the safeguards, with as also Professor Maggieri said before. Maybe during throughout the years, the European courts, but also the praxis will elaborate a specific framework for this kind of proceedings. We can say here that from the wording of the regulation, particularly from recital 18, we can find out that there is a couple of different standards for like confiscation based on conviction. All the safeguards and all the procedural rights coming from the European Framework Decision from 2010-2016 are applicable. But also all the safeguards set out in the Charter of Fundamental Rights of the European Union, while, and this is considerando 18 states, giving us a further proof that the regulation applies also to no conviction-based confiscation. It says that for as regards these proceedings, the proceedings regarding no conviction-based confiscation, only the essential safeguards set out in the charter have to be applied. So at least as we as we have been saying before, the right to an effective legal remedy, the right to have a judge third and impartial, and also all the right of the defense. The last one, which apply to both freezing or confiscation, is the manifest breach of a relevant fundamental right, upon which Professor Margeri has been already touching on. Yeah, no? Oh. Yeah, coming to the end of the presentation, so in absence of ground for refusal, the executing authority shall recognize and execute the freezing or confiscation order, and taking all the necessary measures again in the same way it would have been done in case of a domestic order. The executing order, just to point out the main provision, shall also promptly provide the issuing authority with information on the outcomes of the execution with a written record, as we also said before, regarding the transmission of the certificate. And there is also this specific provision which is very interesting and which is in the framework of the cooperation, the loyalist cooperation and widest cooperation between the states involved. Even though the issuing authority does not issue a freezing order, the executing authority may freeze the property once they recognize, or even before they recognize, mainly before they recognize the order, may freeze the property concerned of its own motion, in accordance, of course, with its national law, or with a view to subsequent execution of the confiscation order. So this can happen during the proceedings in order to recognize and execute the confiscation order. The case is when a confiscation orders comes in, and when the authority deems that it would be dangerous to not to freeze regardless the fact that the issuing authority did not issue any freezing order, not to freeze the consent property. At that point, the executing authority may freeze the property with a view to executing the confiscation order right after the conclusion of the proceedings, of course. As we've been saying at the beginning, the principle of mutual recognition also has this other exception, apart from grounds for refusal, also grounds for postponement of recognition executions are provided for by the regulation. So the executing authority may postpone the execution of a freezing or confiscation order, Articles 10 and 21, in the following cases. Possible damage to ongoing criminal investigation is something not new. Actually, also in other judicial cooperation instruments, we can find this kind of provision, but also in many often bilateral treaties, also with non-EU member state. Existing previous national freezing or confiscation order. Of course, the provision is a bit not that simple. There are like anyway other elements to be taken into consideration. Then only for confiscation, legal remedy invoked according to Article 33 of the regulation. And then this specific hypothesis a bit complex. We can read it out. It regards the confiscation order concerning an amount of money. In this case, the executing authority consider when the executing authority considers that there is a risk that the total amount obtained from the execution of that confiscation order might consider exceed the amount specified in confiscation order because of the simultaneous execution of the confiscation order in more than one member state. In that case, the executing authority may postpone the recognition or execution of the confiscation order. Some final comments on the other provisions. Article 9 and Article 20 for either freezing or confiscation, set out the time listing for recognition, execution, and freezing or confiscation orders. Article 13 and Article 22 still regarding to either freezing or confiscation outlines a provision regarding the impossibility to execute a freezing or confiscation order, and this is a kind of material impossibility, of course, not legal. And finally, the case of a transmission of a freezing or confiscation order to one or more executing states due to either the presence of goods in different states or any way to necessity to take action from more than one state in order to have the recognition and execution from one single state. And as regard this case, Article 5 and Article 15 with regard to freezing and confiscation outline the relevant provisions. And this is all.
Thank you so much, Dr. Fini, for this so interesting presentation in order to explain better also for practitioners how to apply the regulation. Now we have a coffee break, and so in a quarter. Okay, thank you. We can start again with our conference now. We have a speech by Karin Sigstedt, prosecutor for Sweden. A moment, Matteo would like to remember some profiles.
Yes. Hi. As you can see from the screen, I repeat the importance for us of having filled the EU survey for understand the impact of our events. You find the references you have to put in the screen for both remote attendances and in presence. And I'm gonna send the link through the chat of the conference, the link of the survey in order for the ones that are following by remotely to fill it out. Thank you very much.
So now I give the floor to Karin Sigstedt, public prosecutor in Sweden. Is here? Yes. Dr. Sigstedt is present. Is not online. Yes.
I was just muted, so I'm here.
Okay.
And I can put that on as well.
Thanks so
So-
much for your participation in our conference.
Yes,
Please, I give you the floor.
thank you very much. If possible, if you can show the presentation from your computer.
Yeah, thank you. Thank you. We can both see the presentation and you. Thank you.
Okay, you see my, yeah, now I see it, yes. So I'm a Swedish prosecutor and I've been working for 24 years as a prosecutor, but I had different positions and I'm now international strategic coordinator and I have special responsibility at my authority on asset recovery, money laundering and other international organized crimes. And I'm also the head of the Asset Recovery Office, the judicial in Sweden. We have both a judicial office and a police office, and I lead the judicial office. So, and I also been working a long time with these questions. I've also been in the steering group for the Camden Asset Recovery Interagency Network for many years, and I also been their head of delegation in FITF also on these matters. So a short introduction to understand the structure in Sweden. We have a bit special because we have two prosecutor authorities. We have the General Prosecution Office and then the Swedish Economic Crime Authority. And we actually, the Swedish Economic Crime Authority celebrated 25 years this year. And it was started because we saw that we couldn't reach the economic crimes and this was a try to focus more on economic crimes, the organized. And I think that has been successful. So compared to the General Prosecution Authority, in the Economic Crime Authority, there's just this focus on economic crimes, money laundering, etc. And we also have a multidisciplinary approach. So within the Swedish Economic Crime Authority, it's not just prosecutors working, it's also police officers, analysts, and accountants. So that also seems to be successful when investigating economic crimes, and also to follow the money. And so I would go to the next picture then. So the mandate of the Economic Crime Authority is, as you can see, bookkeeping offense, crimes under the Tax Offence Act, crimes related to bankruptcy, company acts, and money laundering and European Union fund frauds. And they have had a lot of MTIC frauds recently that we have investigated. So we can go to the next slide. And as I said, then we have this multidisciplinary approach that we work in teams led by prosecutors and in the investigations. And then the teams consist of all these different specialists. So that's the approach we have. So I can go to the next slide. Yes, so as I said, we have in Sweden we have 2 asset recovery offices. One is with the police and one is the judicial, and that's the one I'm heading. And we are then we divide it that we are responsible also for the General Prosecution Office on their requests and questions on asset recovery as well. So, and then in the office, we have 3 accountants working, handling the different requests, and to try to search for the assets. And we have a lot of advice on freezing and trainings. And in the work with FITF and also the work with Karin, we could see that a key to success for freezing is that you first can very quickly find the assets in the other country, and that all organized crime or economic crimes, they are borderless, so to say. So you need to be very quick to find the asset and bank accounts or real estate in the other country, and then it's too heavy or too long to use actually an MLA or to use the freezing order, because you don't know where to send it. So and as you are well aware, there is also the directive on asset recovery and on confiscation now ongoing, and negotiations with the European Union, and to strengthen the asset recovery offices. So we work a lot to really promote asset recovery offices, and so that this information can swiftly then also be used within the freezing order to aim the freezing order to the correct place. So, and then we go to the next slide. So in Sweden, we have a chapter within the criminal code, and first is in the procedure code, which says that in Sweden a prosecutor may take property, freeze or seize, which can later on be the court's decision on confiscation. And it's also possible for the police officer to seize movable property, and if it has to be done very promptly, but then it must be also under the prosecutor's decision later on. I would say that in Sweden, prosecutors had a quite wide range of powers compared to many other countries. And next slide then. So the grounds for the freezing order in Sweden would be seizure, and that's on a prosecutor decision. It could also be a money seizure, and it's according to our money laundering crime legislation that will also then be a prosecutor decision. And then it could also be confiscation, then it's a court decision, and it's a value-based sequestration that is the ground for the confiscation decision. And it could also then be extended confiscation, which is a court decision on value-based sequestration as well. So we can go to the next slide. So, and in Sweden, the closest at the moment that we are to non-conviction based confiscation is our law on extended confiscation. And that's in the chapter 36 in the Swedish Criminal Code. And this was just for some years changed. So it's quite a wide scope. It says that a person guilty of an offence for which imprisonment for 4 years or more is provided can then be object for extended confiscation. And 4 years, all more severe crimes have that in the scale. So it's almost all serious crimes would go under this. And with what has to be proven, which is highlighted in also in yellow there, is clearly more probable than not that it is the proceeds of criminal activities. So that's the burden of proof for the prosecutor. And now we had this legislation for some time, so this is developed. It was very difficult in the beginning, but now it seems that we have come to sort of a standard, what clearly more probable is. At the time when this legislation came in 2008, there were a lot of discussions in Sweden, and the first suggestion was to have an even lower burden of proof. But this is what came out of it. And we can go to the next slide. So also it's possible with extended confiscation without the limitation of the 4 years when it comes to specific crimes. And you can see they are here, this data security, exploitation of child for sexual posing, take a bribe, child pornography, narcotic offense, doping offense, narcotic smuggling, smuggling of human beings. And those crimes, then it doesn't matter if it's possible to have the 4-year imprisonment or not. And then there is one even wider opening, which is the last bullet point, that some other offences for which imprisonment for 2 years or more is provided, and that form part of an organized criminal activities. So if you can show that there is an organization, 2 years is almost all crimes in Sweden, offenses. So then you can be the object of extended confiscation. And the provision also apply if a person is guilty of attempting, preparation, or conspiracy to commit an offence referred to. So this is, I think, quite wide scope. And so what happens in Sweden is that one of these crimes just triggers the extended confiscation. So the money or the assets don't have to have any connection to the crime at all. It's just that if you commit one of these crimes, that triggers the possibility to extended confiscation. So we can go to the next slide. So and the persons or objects for the confiscation or extended can be from the perpetrator or another person who was accomplice to the offense. That is the basis of the confiscation. And under 2, it's a person who acquired a property through an estate distribution or due to bequest or will or through a gift. 3, a person who acquired a property in some other way and thereby knew or had reasonable cause to assume that the property was connected to criminal activities. So that is the scope of the extended confiscation. And we can go to the next slide. And for the more pure form of, if you can say so, non-conviction-based confiscation, where there is no judgment at all, which is required then under extended confiscation, the only time that is possible in Sweden is when it's due to death. So it's not possible to impose a penalty. Property may be declared confiscated, or corporate fines due to the offence imposed or measures ordered to prevent abuse can then be used. And I would like to go to the next slide. So with the freezing order today, from a Swedish point of view, we see some more national challenges because as a ground for the freezing order, it's just, as I said, it's confiscation or extended confiscation or seizures. So victim compensation, then it's not possible to have a freezing order. And we see also a challenge. As I said, it's important to very swiftly trace the assets, and that's also why we're promoting very hardly the Asset Recovery Office and also the carry network, because often the money or assets are gone by the time the freezing order is in place or is sent over. And what we also see as a challenge is the focal point. It's very difficult to find where in the country you should direct the freezing order. And I think in that combination, also the feedback on the freezing order is very difficult to get. And we actually had at the Commission, the Euro platform meeting yesterday, and other colleagues had also experienced the difficulties with the feedback. You don't know what is actually seized, and then there was a suggestion in the meeting to perhaps have a template where when you freeze something on the freezing order, that you can also explain what has been frozen or not. So I think that's the main challenges we see with the freezing order. And I can also say that there are suggestion and under discussion a new legislation quite completely on confiscation in Sweden, and where will be a non-conviction based confiscation that will be more towards unexplained wealth order. and we'll see how it ends or what the final suggestion will be. And there is also a suggestion that damages will foremost be confiscated by the state, and then the victims can, from the state, receive the money. And that would be very, I think, beneficial for the freezing orders, because then that would not be an issue in Sweden anymore, that we can't issue them on the grounds of damages. So, but there are the discussions then how we can proceed with this perhaps new then non-conviction based confiscation. So, and then I just have a final slide. It's just a logo of the Swedish Economic Crime Authority. So I think this was as short as promised. So, but thank you very much for the opportunity. Thank you.
Thank you so much, Dr. Sigrid, for this presentation. So we have also this opportunity to know the Swedish modus of confiscation. I would stress the extended confiscation is based on a clearly the standard of the proof of the directive Article 5, clearly more probable, a kind of standard between civil standard, criminal standard of the proof. No, not it is the clear and convincing evidence of the system of common law is about. Thank you so much for this presentation. Now we have Professor Stibel Lerner for Austria about the Austrian models of confiscation. It's okay, Professor? Yes. Thank you so much. Please, I give you the floor. We are not able to hear.
You should turn on the microphone. You should be authorized to do so. One moment.
Sorry, can you hear me now?
Yes.
Yes, perfectly. Thanks.
Perfect. So, buongiorno e grazie for the invitation and the opportunity to take part in this most interesting conference. My name is Katrin Stiebel-Lehner and I'm from the Johannes Kepler University in Linz. I was asked to give a brief overview of the Austrian models of confiscation, which are covered by the regulation. Given the time slot, I'm going to draw a very basic picture of the legal situation in Austria. Please feel free to ask any details afterwards, and I'm also happy to provide the presentation slides, or rather have them provided. Could you start the presentation, please? Thank you. So for the next slide, you see a quite complex chart, therefore the willingness to provide the presentation slides. You find the four main types of confiscation orders in Austria. However, there are a few more models in ancillary criminal codes for special circumstances. All of the models are covered by the regulation. Let's start with the next slide, with the sanction that is actually called confiscation in Austrian criminal law. confiscation under Section 19a Austrian Criminal Code is undoubtedly a penalty, or more precisely, a secondary penalty to imprisonment or a fine. So much for the legal nature, in short. Please go on with the next bullet points. An item used or intended to be used in the commission of an intentional offense, and any item produced from such an offense is to be confiscated. It has to belong to the perpetrator at the time of the judgment at first instance, due to the legal nature as penalty. So this explains the requirement of sole possession of the item by the accused. It is therefore not permissible to confiscate instrumentalities and products of crime which belong to a third person under this section of confiscation. Confiscation also extends to the replacement value of these items if they belong to the perpetrator once again at the time of the conviction at first instance. Confiscation shall not occur if it is disproportionate relative to the significance of the offense or the responsibility of the perpetrator. So this is, in short, the confiscation in Austrian criminal law. However, there are a few more confiscation types, as you can see on the chart and on the next slides. There is a sanction called seizure. Instrumentalities and products of crime can be seized under Section 26 Austrian Criminal Code. You see the explanation on the next slide. These instrumentalities and products of crime which can be seized independent of ownership if they were criminally dangerous items. That's the prerequisite. That is, if the specific nature of the item deems the seizure necessary in order to combat the future crime of offenses. This is due to the legal nature of seizure because it's no penalty, it's a preventive measure and therefore no prerequisite of ownership. An object may not be seized if an authorized person removes or renders useless the specific properties or nature which facilitate the commission of offense. So much for the exclusion. If the requirements for seizure are given, instrumentalities or products may be seized even if no particular person is prosecuted or convicted of the offense due to its dangerous nature and the legal nature of preventive measure. You'll see confiscation and seizure are quite similar in Austria. Two sanctions, but quite similar. Due to the legal nature, they differ in some parts, as you see on the next chapter, on the next slide. Seizure and confiscation are quite similar. So much for them. The central sanction, I have to say, in Austria is forfeiture. It's the central confiscation order, so to say, because it includes any assets acquired for of ruin offense. You can see on the next slide the bullet points to forfeiture, called Verfall in Section 20 Austrian Criminal Code. Any assets acquired for of ruin offense are to be forfeited to the court. So in short, forfeiture also extends to any benefits and replacement value of assets that are to be forfeited, unless the assets to be forfeited are secured or seized. The court has to forfeit the monetary equivalent of these assets, so it's a really wide range of forfeiture. The court has discretion to determine the extent of asset forfeiture if the determination of the true extent of the assets that are to be forfeited is either impossible or involves excessive effort. Forfeited assets do not necessarily have to be owned by the convicted person, because forfeiture is not seen as a penalty but a sanction sui generis. This is rightly doubted in cases where forfeiture is more than reversing illicit enrichment, because the law allows to neglect investments of the perpetrator, for example, costs for the purchase of assets. So the so-called cross principle makes the legal nature of forfeiture more a penalty than a sanction sui generis. This is a big dispute in Austrian criminal law, but the court, also the High Court of Austria, sees it nevertheless as sanction sui generis. If the assets are property of a third person, forfeiture is possible except under certain conditions. In a nutshell, forfeiture is not permissible if the uninvolved owner of the asset was unaware of the offense. Forfeiture shall not occur insofar as the process and efforts required to realize the forfeiture are excessive relative to the value of the assets that are to be forfeited or to the prospect of achieving the forfeiture. Lastly, there are 3 types of extended forfeiture in Austria, 3 very different types. All of them target assets that are not involved in the crime for which the perpetrator actually stands trial. Extended forfeiture is not a penalty in Austrian criminal law, but rather a sanction sui generis. It's very preventive. The courts have to confiscate any assets belonging to criminal organizations and terrorist associations, as well as funds for terrorist financing. The only prerequisite is that the assets are in the possession of the criminal organization or the terrorist association, or that the assets have been provided or collected for the financing of terrorism. The existence of such an organization or the use or intended use of the assets for terrorist financing has to be proven. But then it is not required that a specific offense has been committed or can be proven. In fact, if these assets were legally acquired, they have to be forfeited as well. Extended forfeiture under Section 20b, paragraph 1 ACC is not permissible if the assets are the subject of legal claims by persons who are not associated with these organizations. In 2011, a second form of extended confiscation was brought into force. You can see the bullet points on the next slide. If anyone unlawfully, but not necessarily culpably, founded or participated in a criminal association or conducted terrorist acts, or if he or she was convicted of an intentional offense punishable with more than 3 years imprisonment, and if assets were acquired for or through these acts, the court has to confiscate any assets obtained in a temporal connection with the offense. That is, if there is reason to assume that they were acquired through an offense and if the lawful acquisition of these assets cannot be substantiated. So extended forfeiture is only allowed if it is reasonable to assume that the property is derived from unlawful but not necessarily culpable conduct. In 2021, a new paragraph 2a was added to Section 20b Austrian Criminal Code that should help to fight money laundering and the financing of terrorism. So on the next slide, you see that assets originating from a criminal offense which were secured or seized during criminal proceedings for particular offenses have to be forfeited if it is not possible to prosecute or convict someone for the crime. You'll see the particular offenses in a minute on the next slide. As for the offense, an initial suspicion is sufficient. There is no higher degree of suspicion required. The court can base the forfeiture of the assets on the disparity between the value of the asset in question and the legal income of the person insured, so a so-called unexplained wealth model of confiscation. The grounds for exclusion of forfeiture apply accordingly to all types of extended forfeiture and are mostly the same as for forfeiture according to Section 20 ACC. The list of offenses relevant for the third type of extended confiscation encompasses these serious crimes you'll see on the slide. You see here that forfeiture and extended forfeiture do not only, on the next slide, sorry, now, extended forfeiture and forfeiture do not only share part of their title, but also some legal regulations by way of reference. But yes, as explained, forfeiture concentrates on the asset acquired through or for the offense in question for the predicate crime, and extended forfeiture concentrates on other assets in a temporal connection or unexplained wealth, for example. So yes, this was a really quick tour of the Austrian confiscation models to honor the time slot given. Thank you for your attention. Are there any questions, or is there time for questions? I'm not sure, but greetings to Milan. Thank you.
Okay. Thank you so much. So I have a question. In your opinion, all these models are covered by the regulation?
Yes, all these models are covered. They are the main types. There are a few other confiscation models in Austria in ancillary criminal law, for example, for drugs. But they reference these types of models mostly. Yes, they are very minor, but also included in the regulation.
Yes, it is interesting because also in Austrian system of law, there is this model of a kind of action in rem. Is also the extended forfeiture in rem against when there is always the suspicion of the commission of the crime, but there is I would like to ask you, which is the standard of the proof when there is the extended forfeiture in rem, for the standard of the proof about the legal origin?
It's very basic. So it's an initial suspicion and mostly reverse of burden of proof.
Okay. Thank you so much.
Thank you.
So, thank you. I hope that we can we will ask if we can include in our database also this presentation. Okay, thank you so much.
Yeah,
So,
it's my honor. Yes.
Thank you. Now we have the presentation of Dr. Susanna Fonte, team leader of the Economic Crime Case Work Unit Operation Department of Eurojust.
Good morning. Good morning, everyone. Good morning to those in the room. Again, we met yesterday Hello to those who are behind the screen and who have not had the chance to meet. I will go through the practical application of the regulation and the experience that Eurojust has had so far. What we are doing. Can we? Oops. Yeah. Without wanting to repeat myself, but there might be some overlaps with yesterday's presentation, but also for the benefit of those who were not present yesterday. Eurojust supports the asset recovery cases. We have the main legal challenges and practical issues and best practices in the report that you see on the screen. The link is there, and also many issues on asset recovery are contained in the report on money laundering, the link of which is also on the screen. Yesterday we spoke one of the issues that we spoke in terms of problematics of the application was insufficient awareness still of the regulation. It may sound to us who are well versed in these matters, but what, for example, we tried to do was before the regulation came into force, we published a little note, a 2-pager on our website. The link is also on the slide, explaining, giving a brief introduction to what the regulation was, the main novelties, and to raise awareness of the start of the application, what that would entail. So not going into detail whatsoever, but raising awareness and giving a brief introduction of the novelties. I will reiterate that Eurojust supports all stages of the asset recovery process. I was delighted to hear Karin Zigstedt from Sweden. I worked with Karin at Eurojust in very many cases. Sweden and Karin in particular contributed to many cases that are in those reports. What we are doing at the moment, we have a project on the application of the regulation. We are analyzing Eurojust cases. I was discussing with Ella, my colleague to the left, how we register our cases at Eurojust. So we register our cases where this instrument is used, and we analyze them, and we are going through them to identify legal and best practices, legal issues, and our report is due in the beginning of next year. Some of you will have been at the first Eurojust meeting on money laundering and asset recovery in June. That took place at Eurojust. We covered some of the matters that you see on the slide, the material scope of the application, the direct applicability of the regulation, where we also touched upon the matter of the domestic law. That is, even when there is a need at domestic level for some domestic, let's say, implementation, so lato sensu. The issue of restitution to victims, affected persons' rights, and whether in the framework of the regulation there were any issues regarding exceptional costs and the freezing of cryptocurrencies. As a result of our discussions in relation to direct applicability, in some countries we saw that there was a misunderstanding as to the nature of the regulation. This was also something that we heard today from Ana Maria. We heard yesterday also from our Romanian colleagues. This broadly and irrespective of whether any changes in national legislation were needed. So irrespective of what you were saying, Ana Maria, before. In terms of scope, we could see that the practitioners welcomed the fact that it encompasses proceedings in criminal matters, and only exceptionally some difficulties with this concept were found. Well, not surprisingly, with Italy, we have seen now, not specifically at the meeting, but we have seen at Eurojust that there have been some cases, but only with some other countries, but with other countries there are no issues whatsoever. With regard to restitution to victims, participants also saw that it's a big step forward, but there are still difficulties when there are victims in several jurisdictions, the Articles 29 and 30. With regard to exceptional costs, there's a role for Eurojust in the regulation, as we know, Article 31. And there was a suggestion for some guidelines to be created by Eurojust. This was not only suggested in the workshops, but also we had a question from a desk, and the economic crime team at Eurojust was consulted about this. What can Eurojust do? What is the experience that we have about this? What can we Eurojust do, or to give some guidance to our national authorities about this? So this is something that we together with yourselves, with the national authorities, with the national desks, we will be doing, just like we have prepared guidelines on conflicts of jurisdiction and on competing EAWs that I believe have helped or have supported your authorities in these matters. We've also discussed issues of concurrent certificates. Article 26 is based only on a single executing authority, but in reality there can be more. We've seen towards the end the support from participants to create a dedicated focus group on money laundering and asset recovery, organized by Eurojust, and the aim, and this comes back as well to this multidisciplinary approach that we were discussing yesterday, to increase national and cross-border international cooperation between the judiciary, law enforcement, and other actors. And by other actors, I mean FIUs, asset recovery offices, special financial specialists in financial investigations, specialists in cyber, to conduct these or to assist and collaborate in financial investigations, to fight money laundering and recover illegally obtained gains, to increase efficiency. If I can now move on to a practical example, a Eurojust example, this is a case of an organized crime group involved in drug trafficking and money laundering. It involves 3 countries. The names are not identified, so I just put member state A, B, and C. It's irrelevant. There were 2 joint investigation teams, one, let's say, with member state A and B, and another one with member state B and C. And another member state executed freezing orders and European investigation orders issued by member state B, the one that had the 2 JITs in common. Now, there were several issues in relation to the freezing certificates, to freezing matters. The executing authorities, so member state D, froze a number of companies in their country, and appointed judicial administrators. And yesterday we discussed as well the fact that in some countries it is the case that this figure of judicial administrators does not even exist, which was not the case in this case. In this case, there was judicial administrators in the executing authority, but this was the first case in this country, in this executing country, where the management of the frozen assets was being done under the regulation. And there were several issues that arose here. There were divergences in the applicable national legislation, and the powers of the judicial administrators in the executing country and the issuing country were different. And the judicial administrators of the issuing authority had to travel to the country of the issuing authority to discuss how to go about the administration. Why? Because in the issuing country, the judicial administrators could not. This was the part that I was trying to speak about yesterday. I need to go to my notes. In the issuing country, the daily management of the companies had to continue to be done by the suspects. So it was not foreseen in the legislation of the executing authority that the management of the country would be done by the judicial administrator, and that was not consistent with the issuing. Let's say that it would be Poland and the Netherlands. Poland issued and the Netherlands executed. In the Netherlands, it would not be possible for the Dutch, it would not be possible for the judicial administrators to carry the administration of the companies. I'm giving examples of the countries. These were not the countries. So the Polish administrators had to go and discuss with the Dutch judicial administrators to see how to go about administrating the companies, and to see if it was possible that a Dutch judge could authorize that you could administrate in the Netherlands the companies, because the Dutch judicial administrators were not going to do that. So this is this was an example. In relation to yeah, that's what I was saying. We also have in our Eurojust money laundering reports. For those in the room, it will be a kind of a repetition. We also cover asset recovery issues and financial investigations. Those that you see in the screen related to national bank registers, financial intelligence units, and the confidentiality of banking information. In fact, what you see on the screen, the National Bank Register, what we did, and that is work that Eurojust also does, is we do what we call operational topics. And that is when a national desk or a team at Eurojust, the economic team, the trafficking team, the cyber team, has questions that they would like to put to all desks in relation to an operational matter. In this case, it was questions related to the implementation of the obligation of a national bank register in how that was being done in other countries. So we made a summary of those and there is such information in the report. We also covered these matters in the money laundering report. They all have to do with asset recovery. And you see that they cover compensation of victims and restitution. This has to do with the regulation. Also asset management, criminal and civil recovery. And I'm trying to stick to the time today for once. And some of the issues are, like I said, that that there is, in some instances, insufficient awareness of the regulation still. Issues relating to who is considered a victim in a given country, who can apply for compensation, and how to ensure that proportionate compensation of all victims when the amount that is frozen is not enough to be restituted to all victims. We've also seen difficulties that arise from the use of cryptocurrencies. They are used more and more, and how useful it is to have, like I said, this multidisciplinary approach, and to have, like we've also seen in our cases, we had one case where the law enforcement, the police themselves, developed a tool to access the crypto wallets. So they did not have to use to buy or to ask the services of a company. They themselves developed the software to access the crypto wallets and to, I'm not in a position because I don't know technically how that it is done, but what for our purposes is important, they were able themselves to freeze. This is what is relevant, and this was a Eurojust case that we followed, and there was a coordination center. Also, what we have seen is the difficulties in identifying the beneficial owner of the criminal assets, and how important it is, especially when this involves third-party confiscation, and then again the clarity in the rules of beneficial ownership and the importance in money laundering and other cases. And this brings us to the progress that is being done and the attention that the EU legislator is putting on in the anti-money laundering package, be it in the transfer of funds proposal that has been adopted already, in the other packages, in the other proposals that are part of the package. We've also seen again issues in relation to determining who is a victim, and we've identified several best practices, like the use of asset recovery offices, even in the apparent absence of a criminal investigation, for the purpose of identifying assets from suspects in other countries. This was something that we have seen in some cases, the use of asset recovery offices, even in the apparent absence of a criminal investigation, for the purpose of identifying assets. In some countries, we have seen, of course, each asset recovery office and each FIU will be organized differently in each country, and we are now with the new proposal be trying to harmonize this and make it more effective. But it's interesting to see how creative we can be when we face difficulties in concrete cases, and the recourse that we make of certain resources. We've seen the benefits of including consideration of asset recovery precautionary measures in joint investigation teams, and also of establishing a JIT solely for the purpose of conducting a financial investigation. This, for example, we have seen in a case where the criminal case was already finished, was already concluded even. Again, cooperation between public prosecutors' offices and FIUs and AROs is essential. And again, like I said, highly skilled experts with a focus on digital devices to take copies of the relevant electronic evidence to obtain access to the crypto wallets is more and more relevant these days. And the benefit of clarifying via Eurojust, where appropriate, the valid legal basis to freeze the funds and for the restitution of the victims. If you have any questions, thank you.
Thank you so much, Dr. Fonte, for this, to stress the importance of the role of Eurojust in this cross-border case in the implementation of the regulation. There are some questions, or we can, please.
Sana, I would like to ask you whether you expect any kind of new regulation in that matter that you mentioned at the EU level, or you believe that what really lacks is the cooperation between countries, and that can be helped by the Eurojust national desks, so that when people cooperate, the regulation really works. When they do not cooperate, whatever you write in the legal rules will not work. So, do you expect any kind of new regulation at the EU level that would clarify, for example, the how we understand the victim, which we already have, the clarification of the minimum definition of a victim in the Victim Rights Directive? Or you think that all we really need, there are good practices that are exchanged or discussed at the Eurojust level between the national desks?
I can only speak in relation to the cases that we have at Eurojust, which are a part, perhaps, and I cannot, I as Susanna, but also as Eurojust, we do not know what percentage the Eurojust cases are in relation to all cases in the EU that involve the application of the regulation. And apart from that, we are still, like I mentioned, still in the early stages of the relative early stages of the application of the regulation, and we are still analyzing the Eurojust cases. We will be in a better, I will probably be, or Eurojust will be in a better position to answer your question when we finalize the report, like I was saying, when we finalize the report that is due in the first part of next year. But in relation, but the issues that I mentioned in the beginning, those mainly those that have to do with the restitution to the victims, the scope, the concurrent freezing orders, those were from a preliminary approach to the national desks, those that appear to be the most relevant. It is now for us to have a look at all cases and all cases. No, at the cases that we have and conclude in general if there is a need or not. But bear in mind that we are consulted normally on the by the legislator on the basis of our experience. But it would not be prudent, and it would not be fair if I would make a statement now without having more solid results. I gave sort of a brief overview of the outcome of the meeting that we had in June, but I will be in a better position to reply to such questions when we finalize the report. Okay, I apologize.
Thank you. I just looked at the casework from the German desk of Eurojust, and the numbers are quite impressive in the way that, for instance, the number of joint investigation teams that have taken place in the years starting from 2017 have been constantly growing. From like 7 at the beginning to 45 in 2019 already. So my question would be: is this a general trend that the awareness of Eurojust of the use of these cross-border investigation tools is growing? And if it is so, is it also a question of capacities that maybe in some point you have, or maybe already now you have too many cases to deal with, or is it still in a good way without too much growth of the numbers of cases and demands?
Thank you for the question. I guess you are looking at the annual report of Eurojust. Yes.
No, from the desk. I checked the casework on the
of
the German desk.
Of the German.
Yeah.
Yes. So
not only not confiscation in specific, but all the cross-border cases, I guess.
Yes. if we look at the Eurojust annual report, and which is a public document, or for example the money laundering report, but your question is broader than money laundering and asset recovery in general. So it is indeed that throughout the years, especially in the last years, there has been an increase, a very large increase in cases brought to Eurojust. There are more joint investigation teams. You will be reminded that we host the JITS, Joint Investigation Teams Network Secretariat at Eurojust. We also host the EJN, European Judicial Network Secretariat, the Genocide Network Secretariat, and indeed we are growing, and there is a demand, and we are expanding. We also have more and more cooperation agreements with third states. We have more liaison prosecutors, and all these partnerships with third countries, for example, especially now in this field of asset recovery. I mean, the monies are very often outside the EU, in countries where we would like to reach, but they are difficult. So trying to establish contacts in several ways, and that we can do by having cooperation agreements. Cooperation agreements are agreements whereby Eurojust can exchange personal data, meaning data on the specific cases with these countries. And the maximum cooperation is when then in these cases we have a liaison prosecutor at Eurojust. And if I'm not mistaken, I don't want to make a mistake, but I think we have 10 or 11, if not more. I don't want to be lying, but we have in the last years increased the number a lot. And also we have over 50 contact points in third states, and these are contact points like we were discussing yesterday, contact points that are that are appointed by third states, and they are in their ministries of justice or in their public prosecutors in their general prosecutor's office, and they can assist when there is a case at Eurojust and there's a need to follow up an Italian request, and nobody is answering in Dubai. I'm making now something up. Something like that. So the more we engage also with third states, and the more we have events like these, the more we engage with law enforcement, the more we is the prosecutors, the judges, the asset recovery offices, but a lot law enforcement and prosecutors and judges, to put it in general and not only focusing on asset recovery, because your question is more general. So indeed, we have seen, we are creating many events to foster the raising discussions like this in several topics with our partners, with Europol, with the EPPO. I mean, this is work that we do together with academia.
Thank you so much. Now, Professor Sokanovic from Croatia, from in particular the Department of Criminal Law of the University of Split Law School. I give you the floor. Thanks so much.
Thank you very much. So my name is Lucia Sokanovic. I am Associate Professor at the Chair for Criminal Law of the Faculty of Law, University of Split. And first of all, I would express my gratitude to Professor Anna Maria Maugeri for inviting me here and to have opportunity to hear experiences of the people who actually work on these cases. Because one thing is to read through the provisions in criminal laws and penal procedure laws, and the other thing is to hear the actual experience. May I just... as I have only 10 minutes and I will keep up with time, I will just go through 3 basic points. So I will briefly introduce you to the forms of confiscation in Croatia, to legal regulation of confiscation and freezing orders, and present you available data concerning Croatia. So in Croatia, we have our Croatian Criminal Code makes difference between, or has legal definition of, regular confiscation and extended confiscation. That is something that is regulated in the Croatian Criminal Code. But if we see the forms of confiscation analyzing all provisions of criminal code and criminal procedure code, then we can see that we have at least 2 basic forms of confiscation. The first is conviction-based confiscation, of course, when the perpetrator is found guilty of the particular offense. Then non-conviction based confiscation. So if the accused person was found, for example, mentally incapable at the time of the commission of unlawful act, then if he is permanently incapable to stand trial or is unavailable to the criminal bodies of the criminal procedure. And the third is confiscation from the third party. So it concerns the family members or another person who has acquired proceeds not in a good faith, or the successors of the perpetrator. The procedure is regulated under the Croatian Penal Procedure Act. At the very end of this act, between the special procedures. So you see the numbers of provisions concerning temporary confiscation, freezing orders, and confiscation procedure and guarantees. So in Croatia, these freezing orders are called temporary measures of confiscation insurance, or ensuring the confiscation. If we are talking about implementation of the regulation, then it is implemented in provisions added to the Act of Judicial Cooperation in Criminal Matters with member states in the European Union. And here you have provisions concerning freezing orders and confiscation orders. I've decided to focus myself mainly in this short presentation on data. So we don't have particular data concerning regulation. I have asked those data from our Ministry of Justice, and I'm hoping to receive it soon. But every year, Croatian General State Attorney presents the annual report, and if here you can see on the slide total numbers concerning requests, freezing orders, and confiscation from 2018 to 2022, and this huge number in 2022 is the number. So you have more than 100 million euros. It concerns a huge case of economic crime. So in 2022, about 48% of the total confiscated proceeds were related to the cases of corruption, and 51 related to organized crime. When we see the numbers concerning freezing orders, total of more than 99% was related to organized crime, and this percent to corruption. And the number concerns this huge case of abuse of trust in business operation. What is the major problem concerning freezing orders in Croatia? I would say that it was the problem that the freezing orders were mainly issued at the time of initiation of investigation. And of course, those are more complex investigations. Statistics show that they last in Croatia not at least, but most of 18 months. And the minor number of indictments were confirmed in this time. So in 2022, Croatia has changed the penal procedure code and started to count this time from the filling of indictments and not from confirming the indictments. Because the fact was that most of the freezing orders had to be terminated, and then once they've been terminated, it's lost. If we see, and this is also, those are also data from annual report of the General State Attorney. So in concerning the judicial cooperation in criminal matters, these yellow numbers, which are the rest, concern the freezing orders and confiscation orders, and foreign judgments ordering imprisonment or other deprivation of liberty. So the numbers are varying. We see that the most substance of judicial cooperation in Croatia concern European arrest warrant or investigation orders. When talking about countries with which Croatia has the major substance of judicial cooperation, then those are Germany, Austria, Slovenia, Hungary, and Italy. And of course, to the largest extent, those offenses are committed within the framework of criminal association concerning drug abuse, money laundering, tax or customs evasion, and others whom you can see here. And that was about all. Thank you. Thank you for your attention.
Thank you so much for also in limited time, but you give us to show us the situation also in the practice, no? In Croatia, so it is real very interesting, and also this problem of the freezing order. No, the problem that there is a limit, temporal limits in order to respect also the rights of the owners, but at the same time there are the problems of the efficiency. There is always this to balance also how much evidence no, in order to adopt a freezing order to avoid also the problem of the freezing order, to mobilize no assets, but at the same time the problem that the freezing order has to be quick, because the problem that in other case the assets were lost. So it is not so also in Italy we have a lot of problems sometimes, no, with this two accidents to balance. Okay, now we have our lunch break, and also for our the people who is connected online, we will start again punctually at 2 o'clock p.m. Okay. We go together in a yeah. Okay. No, però forse possiamo anche iniziare. With somebody, if there is okay. Good afternoon. Maybe we can start also for some of the experts of other countries. If Professor Boat is connected, we can start with yes, is here. Okay, we can start with Professor Boat, Professor of Criminal Law in Norway, with his contribution. Is it available? Okay. Professor Bogut is there? It's not. Professor Bogut is ready to give your speech? Lo so, però se non ci muoviamo, non c'entriamo, dobbiamo iniziare. Sto cercando di fare incominciare subito. Professor Andrejova or Beznik? Oh, okay. Okay.
I'm there.
Yes? Dov'è? Who is? Ah, Beznik? Yeah. Oh, Bogut.
But you have to enable microphone and camera. Beznik. Okay.
Expert for Slovenia. Thanks so much for your participation in our project. If you are ready, I give you the floor.
Thank you very
okay.
Thank you very
Please.
much. Good afternoon. I hope you can hear me.
We
The
are not
connection is
able
good.
to hear you.
Can you hear me?
You have to turn on your microphone.
Can you hear me now?
It's on.
Can you hear me?
Okay. Yes. We
Thank
can
you
hear
so
you.
much.
Thank you so
I
much.
apologize. Good afternoon. Thank you very much for this kind invitation. My name is Andrej Bežnik. I'm a professor of criminal law in Slovenia, but I also work for many years for the European Parliament, also on issues of criminal cooperation and judicial cooperation. I will just give you a brief overview of the Slovenian system of confiscation. The Slovenian system of confiscation has two tiers. You have a criminal side of confiscation, and since 2011, you have also a civil side of confiscation. Of course, Regulation 2018-1805 applies only to the criminal part of confiscation. Anyway, if you allow me, I will just also address the civil part of confiscation. This is based on a specific law that was adopted in Slovenia in 2011. It's a law about acquiring illegal property. However, this law, civil confiscation, caused some constitutional issues in Slovenia. For example, the law applied retroactive application, and this the Constitutional Court found to be a violation of our constitution. Why I'm raising this law? Because this law, in my opinion, is also a kind of hidden criminal law confiscation, as all the parts of this civil confiscation in Slovenia goes on by rules of the criminal procedure. Only in the last case you include the civil court, and therefore the whole procedure is nominated as a civil procedure. And as it is a civil procedure, there is also a reversal of burden of proof. So just for a clarification. But now I will go to the main part, to the criminal part of the Slovenian confiscation system. This is based on several provisions of our criminal code. These are provisions of Article 74 till 77C of the Slovenian Criminal Code. We have quite a limited, let's say, possibility of confiscation in the criminal code as such. You have a classical confiscation where either the illegal property benefit, the property corresponding to such property, or an amount of money as the third possibility can be taken from the perpetrator or the person who directly received such benefit. Then we have a much more limited possibility for third persons. For third persons, they have to be fulfilled two criteria. First, the amount was transferred without payment or to an amount that did not correspond to the value of the property. And the second element is the person had to be aware that the property was illegal or stemming from a criminal offense. This does not apply to persons relatives to the perpetrator. The code provides in Article 224 specifically who are considered relatives. There, the subjective condition does not apply, and there is also a reversal of the burden of proof that the transfer is always considered to be below the amount of the value of the property, but the person has the burden of proof to prove that this is not the case if it is a relative as a third person to the perpetrator. The same reversal of burden of proof applies to a legal person if the legal person is by majority controlled by the perpetrator or the person who directly got the property benefit. As regards extended confiscation is in Slovenia very limited. It exists in connection with a criminal organization, confiscating from a criminal organization, but not to the criminal organization as such. For a criminal organization, let's say the extension of possible confiscation is limited to the criminal offense for which there is a conviction, but it applies extended confiscation to individual members of the criminal organization. There is a possibility of extended confiscation based on criminal activities there that were conducted in the framework of the criminal organization by such individuals who are members of a criminal organization. As regards the transposition or the application of Regulation 1805 in Slovenia, of course, it is a regulation. Therefore, the Slovenian legislator took a decision that there is only a very small part of the regulation basically transposed into national law, and for the rest, the regulation should be directly applicable. I did mention there is also a small part of non-conviction based confiscations in Slovenia, but this part is not regulated in the criminal code, not in criminal material law, but it is regulated in the criminal procedural code. In the criminal procedural code, we have an article 498A, and this article provides the possibility for a non-conviction based confiscation, but only for specific offenses connected with money laundering or certain corruption offenses. In that case, you can have also a non-conviction based confiscations. But I have to say the provision is not used very often, and it causes a lot of issues or questions in practice. For example, some are of the opinion, judges and experts, that there is no limitation period to use such an article, that the normal limitation period for the criminal code for confiscations does not apply. There were also disputes or different views. What about if there was a judgment based on time limitation, which in Slovenia has a specific name, or a judgment where a person was found not guilty because there is no guilt, but all the other elements of the offense were there. So there also opinions differ, but recently an appeal court in Ljubljana decided if you have a judgment based on non-guilt or if you have a judgment based on time limitation, you cannot use this article. So you see the possibilities in Slovenia more or less are quite limited as regards possibilities of confiscations. This might change in the future with the new proposed directive on asset recovery. You know that the European legislator is debating about a new proposal for a directive on asset recovery. This new proposal would introduce certain new forms of confiscation in criminal law across the European Union. For example, in Article 15 of this proposal, there would be new forms of non-conviction based confiscation, including also cases where a person died, or cases of immunity, cases of time limitation. And there is another new Article 16 in this proposed directive, whereby a new form of confiscation based on unexplained wealth in connection with a criminal organization is introduced. However, I have to say that if, let's say, this proposal would be adopted in the form as proposed by the Commission, this might trigger some legal and constitutional issues in Slovenia. For example, the case of a death of a person, there could be the question of presumption of innocence if you anyway continue with a procedure under criminal law, not under other kinds of law, but under criminal law. In Slovenian law, there could be also a question in the case of time limitation, because the Slovenian Constitutional Court pronounced that a judgment based on time limitation on which the case was rejected basically is the same as a judgment as regards that the person is found not guilty, and in this sense the presumption of innocence fully applies. So perhaps this harmonization might solve certain issues when Slovenia has to apply a regulation 1805 for incoming requests from other member states that have forms of confiscation not necessarily known by Slovenian law. However, it might trigger more serious questions of a constitutional nature and very serious questions that perhaps national constitutional law would be in a certain conflict with that the national constitutional law could be then in conflict with European law, causing the so-called Solange conflicts. So I would finish for the moment here, but I'm open for any questions or remarks, and I can provide further details if necessary. Thank you so much.
Thank you so much, Professor Herzebenik. I would like to ask, in your opinion, the non-conviction based confiscation, which is provided for in the procedural criminal code, is covered by the regulation?
Yes, it's covered. It's covered.
Yeah.
Whatever is in the criminal code and in the criminal procedural law, both forms are covered by the regulation. But the civil part I mentioned before is not. So the civil confiscation based on this specific law, this is not covered under the Slovenian system.
Civil confiscation, sorry, can you better explain what do you mean for civil confiscation? Why is civil? Is connected always? Is always connected with the proceeds of a crime or instruments of a crime, or?
It's connected with the first suspicion that an offense has been committed. So there is a suspicion, like in criminal law, but the lowest basis to start a procedure, let's say at the police phase, there is a specific procedure that is being started that can be conducted by the police together with tax authorities, customs authorities. It's called a financial investigation. In this financial investigation, they basically use a lot of rules as in criminal law, but it's not a criminal procedure. It's a specific kind of investigation. But at the end of this investigation, when they have the result, they do not go to a criminal court. they go to a civil court, and the civil court
Is always in a judicial authority. Yes.
Yeah, it's a judicial authority that decides at the end. It's a civil court. Just the main difference is that the civil court, it's not like in criminal law. In criminal law confiscation, the burden of proof lies in principle, with some rare exemptions on the prosecution. In this civil case, it's a reversal of burden of proof because they say it's civil confiscation, and you have to prove that you acquired the property in a legal way, because they claim that this civil procedure is an in rem procedure and not an ad personam procedure. I have to be sincere, I have some doubts about this,
Yes.
because too much are authorities using criminal law, too much is based on criminal law, and only in the last phase suddenly you say, it's not criminal law, it's a civil proceeding, and we reverse the burden of proof. Thank you.
Yes, also I have some doubt about the fact that it is not covered by the regulation, because the concept of a proceeding criminal matter is very extended to each proceeding which is connected with the proceeding or instrument with the crime, with crimes. And also in the opinion of the European Court of Justice, for example, Bala's case, the definition of a criminal judicial authority is very extended, because it is not necessary that is an authority which has only criminal competence, but it is possible that is an authority which has also criminal competence, or that in any case which works in a proceeding which has the essential characteristics of a criminal proceeding. So if you speak always about a judicial authority in a proceeding with some rule of the criminal proceeding, is possible. The problem is that in the end the a complete rebuttal of the standard of the onus of the proof, rebuttal of the onus of the burden of the proof is not possible also for our regulation on our directive. So the limits is that, but it is a case to maybe to study. Thank you so much for your contribution, and now I give the floor to our representatives for Spain. José Miguel Company Catalá, Senior Spanish Public Prosecutor working in Madrid as Deputy to the Supreme Court Prosecutor in International Cooperation.
Thank you very much. May I have the... Okay. Okay, thank you for giving me the floor, and thank you for advance my presentation, because I have to leave. As I announced yesterday, I'm going to try to speak more about our national problems, our national issues, and I've also talk about the issuing and the executing authorities, and finally some statistical data. Okay, first is that we don't have passed a law for the new regulation. Is not mandatory, of course, because it's a regulation, not a directive. But we think that it should be clarified the authorities in charge of the execution, and take advantage of the reform to establish some new rules on the proceedings of this kind of matters. We only have this nota instructiva. It's kind of like Mr. Fini said before, is kind of recommendation of the Council of Judiciary for judges. But of course, judges are independent, and they don't have why to follow this note. And Dr. Malgeri has talked previously about the thing of the proceedings in criminal matters. But for some judges in Spain, is also an issue. Is not clear, and probably it would be clarifying some resolution of the European Court. Well, that's not important. Main regulation futures as for Spain, the 2 or 3 important questions are from the medium at the end of the slide. Also for issuing or for executing in Spain, the competent authority is always a judge. We prosecutors have not any power in this matter, and we made 3 declarations to the regulation. These are the 2 of them, and I speak about the third after. We need the certificate translated into Spanish. If the issuing authority is in a very urgent case, he or she can send to my office the certificate in English, and we start to deal with it, but we will need the translation previously to send the certificate to the court. And the second declaration is that we need also the internal decision, but in that case we don't need that the declaration, the decision, sorry, has to be translated. Spanish issuing authorities for freezing orders or for confiscation orders are always judges. For freezing orders, the investigating judges. And for confiscation orders, the court that is in charge of the enforcement of the sentence. We have these juzgados de ejecutorias is in the main cities, Madrid, Barcelona, Valencia, and so on. There are specific courts for executing the sentences. Also, they have not passed the sentence, but they will be in this case in charge of issuing the certificate. And we also have the power for the European delegation of the European prosecutor to issue certificates in the matters they deal with. As for executing authorities, again, in Spain is always the judge. For freezing orders, it would be the judge where the properties or where the bank account is located. And for confiscation, also the judge, but not the investigating judge, the criminal judge, the trial court, where the item, where the asset is also located. UCIF is the letters in Spanish of my office, the Central Unit for International Cooperation in the PPO. And this is the third declaration that we made to the regulation. If the issuing authority doesn't know where to send the certificate, which is easy because if you remember, I yesterday explained that we have more than 3,000 judicial districts. And even with the help of the Atlas, it's not very easy to find where you have to allocate the certificate. You should send the certificate to us, and we represent you, and we allocate in the correct investigating court. And the same is for the confiscation certificate, because the situation is the same. We have a lot of districts for trial courts. Okay. Yesterday, someone was talking about this question of if an EIO is needed. In Spain, an EIO is needed in order to locate the amounts in the bank accounts, or to investigate about the property assets. And one of the usual mistakes is that we receive a lot of EIOs saying, please freeze or soft freeze, sorry, the amount or the property while the proceedings are ongoing. We can't. We have not any power. Then we have to make consultations with the issuing authority and ask them that they send us a certificate. It's perfectly okay if you send the EIO and the certificate to the same time. We make the investigation, and after we allocate the certificate wherever is the competent court, but we cannot freeze in any way nothing while we make the investigation. The only way is what I also said yesterday. Through the Financial Intelligence Unit, they have this power of 1 month of soft freezing, but we don't have any power regarding that. Banking information is okay. As the rest of the countries, we have also some problems for tracing assets. We don't have a central register for bank accounts. We have to ask for the information to any single bank company. We have, of course, financial intelligence unit and AROS, but most of the judges are not using them. They are very misused. Issuing a freezing certificate to Spain is what I want to say in this slide. You have to have passed previously a judicial decision. You have to fill, of course, the certificate and the annex, and you cannot modify or handwritten or something like that because the judge immediately refuse the execution. We just need the decision without the needing of translate. And as where to send the certificate, if you don't know where, you have to send to us. And if you know where the property is or the bank account is, you have to send directly to the investigating judge. You can be helped by Atlas or European Judicial Network or Eurojust, but you can also consult to us where I have to send that, and we can tell you. Well, this is the a slide about what every country has done. As you can see, Spain are the latest. You have to send the certificate directly to a judicial authority, not to a central authority, and we need the translation of the certificate, but not the translation of the decision. This is also okay. Here arise the main problems. As we also spoke about yesterday, we have the problem of the land register. It's not enough that the investigating judge orders the freezing, but the freezing has to be registered in the property registry. Then we have two options, but the two options, as Jan-Elise said also yesterday, give us a lot of problems. If we opt for try to appoint in the registry the freezing order, we have the problem with the deadline. It's just 4 years. And we don't have any possibility of control this kind of deadline. The countries who has attached a liaison magistrate in Spain usually can control this deadline, but we prosecutors cannot control this deadline. There are a lot of courts and internal and external problems with freezing, and it's not possible. And as for the judges, it's a matter of the competence of the clerk. and most of the clerks of the judges doesn't have a registry or a ward or an agenda or something controlling the deadlines. Then is difficult. But if we opt for the other option, with to inscribe in the registry a banning of disposal, the banning of disposal impedes to the alleged criminal to sell the property, but it doesn't impede to make a mortgage or another kind of contracts. Then it's also not the best option. And we have also in this matter a problem with for the next phase of the recovery project, but I announce now a problem with the titularity of companies. It's not written in the law if the judge can make an investigation in order to show that behind the company there's the person, the real criminal. Some judges do it, but most of the judges say that it's not in his competence and refuse to seize a property if it's in the name of a company. It's also a big problem. And finally, for statistics, we have two separated statistics. These 2/3 slides are from the statistics service of the Council of the Judiciary. And I ask you that you try to remember the figures. They say that in 2021, they executed 42 certificates, and in 2022, 52 certificates. But now you will see our numbers in the prosecution office. We have this management system. It's not possible to deal with a file in the prosecution office if we don't register the file in this system, and the system explains you whatever you want: the country that issued the certificate, the court where you send it, etc. And if, according to our dates, we sent to the courts 67 certificates in 2021 and 96 in 2022, you can see that the previous figures from the Council of the Judiciary are not real, because they say they are just executing 40-something or 50 certificates, and then what happened with the other 40 that we have sent to the courts. Then we repeat again the need in Spain that we gain the competence of be the single point of contact of receiving the certificates, just in order to clarify for the external authorities where they have to send the certificates. And second, just to clarify the thing of the data and the statistics. Thank you very much.
Thank you very much.